For the meeting, are we streaming? Okay. Welcome to the April 3rd, 2025 meeting of the Athens-Clarke County Planning Commission. Before we get into the agenda, I just have an announcement to make regarding a change to the order of items on the agenda. And that is that items 1 and 2 and 10 under the new business section of our agenda are going to be moved to the top. And we'll take those items first. For two reasons. We have a couple of items where the applicant intends to request a table. And then two items in which Athens-Clarke County has outside counsel here to comment on the items. One of those is item 10 under new business. So we're going to move those items to the top so that outside counsel can stop billing and go. Yeah, so with that said, we will start with the general business section of the agenda. I'm sorry, let me just first make the initial announcement. For those of you viewing the meeting remotely, you can find the meeting agenda on the Planning Department website at accgov.com/planning. For those attending here in the room in person, on the table by the door, you'll find a sign-in sheet and copies of tonight's agenda. For each agenda item, we will begin with a report from ACC Planning staff, and that will be followed by a presentation by the applicant, not to exceed 10 minutes. We'll then open the floor to comment from members of the public. 3 minutes are allowed for any member of the public who wishes to address the Planning Commission. When addressing the commission, please begin by stating your name, address, and the nature of your interest in the project, and direct your comments to the Planning Commission and not to the applicant. The audience is instructed to refrain from applauding or jeering speakers. Exhibits may be displayed by the applicants or by members of the public at the podium. Written correspondence received by noon yesterday has been forwarded to the Planning Commission and is part of the public record. Any additional written materials to be placed into the record must be read aloud during public comment within your 3-minute time limit. For all speakers, please pay attention to the timing device near the podium. That device will display a yellow warning light when you have 30 seconds left, and then a red light when your time is up. After the public comment period, the applicant or their representative may request a 2-minute response. And after that, the applicant will take their seat in the audience. At which point the public portion for the agenda item is closed and the Planning Commission will proceed to discuss the item. We will receive no additional public or applicant comments unless requested by a planning commissioner. And finally, please note that the microphones in this room are sensitive and that the meeting is being broadcast live. Please turn off or silence yourself. So, we'll begin with the general business section of the agenda. Item 1 is introduction of staff reports and all other documents submitted to the Planning Commission at this meeting in the official record.
So moved.
Okay. Motion by Sarah Beresford, second by Kristen. All in favor?
Aye.
Any opposed? Item 2 is approval of the March 6th, 2025 Planning Commission meeting minutes. Are there any corrections to the minutes? Motion by Sarah, second by Kristen. All in favor? Aye. Any opposed? And then item 3, May courts review and public comment. Bruce, is there any May courts?
Nothing to report.
Okay. Is any member of the public by chance here to comment on May courts? Okay, that brings us to the 3 items that we've moved to the top of the agenda. Item 1 is 493 Prince Avenue. Item number zone 2025-02-0375. We'll normally begin with the staff report, but based on communications we've received from the applicant, I'll invite the applicant to come to the podium.
Hi.
Good evening. Please introduce yourself and name and address.
Yeah, sure. My name is Krista Mason. I live at 260 Hill Street. I am the owner of the business at 493 Prince Avenue, the Lark, my space.
Okay. And what is your request?
Well, my request as of a few hours ago, we would like to table the discussion for the rezoning for the project.
Okay.
Based on the, just a lot of conflicting information, and we just want to make sure we're doing the right thing for the business and also for the neighborhood and everybody involved. So before we make any sort of like firm decisions, we'd like a little bit more time for council on it.
Okay, and let me ask Bruce, if a member of the planning commission makes a motion to table, do they need to specify a length of time, or is there a default length of time, or is there room for, 30, 60, 90, what are the options?
There's room for latitude. It's a 40-day window. So what that normally works out to is the next available agenda. So in this case, that would be the January agenda. So no, to answer your question, I mean, a table would inherently mean, up to 40 days, which is, going to be that next cycle. That's really the option.
That's the minimum, and it could be longer if.
I think that's it.
Oh, that's just what it is. Okay, so understood. All right, thank you. We will now discussion back here to the planning commission. Is there a motion?
Public comment.
Oh, I'm sorry. Yes, we allow public comment. Is there any member of the audience here who wishes to comment on this application? Okay, seeing none, now we will bring it back on, and I would entertain a motion.
I move to table.
Okay,
A second.
motion by Sarah Beresford, second by Jennifer Please, and all in favor? Any opposed? Okay, motion carries unanimously. All right. Thank you. And that brings us to item 2 under new business, 349 South Oak Street. Item number SP-2025-02-0374. And again, based on communications from the applicant, the planning director, we're going to skip past the staff presentation and just welcome the applicant to the podium.
David Ellison, on behalf of the applicant, Brian Alston, he wishes to withdraw his application.
Okay, thank you. And Bruce, procedurally, we just, again, do that by motion.
Correct.
Yeah, thank you. Mr. Alston. Is there any member of the public here who wishes to comment on this application? Okay. Back.
I'll move to grant the applicant's request to withdraw.
Okay, motion by Sarah Beresford and second by Kristen to accept the applicant's request. Is there any discussion with that motion? Okay. All in favor? One opposed? Okay. Carries unanimously. And that brings us to the third item, which is item 10 under business, the text amendment concerning short-term rentals. And on that, we will begin with the staff report.
Okay. What I'm going to do,
Oh, I'm sorry. Excuse me, we first have an announcement from Commissioner Sarah Beresford. Okay.
I just need to recuse myself because there's a conflict of interest.
you have 3 text amendments sitting in front of you, so under reference is the thicker of the 3, I would argue. At the top, it says, text chapter 9-1528 and 9-15-29. Both of those code sections, as well as a handful of connected sections of the code, were originally considered and adopted in February of 2024 to create the ability to regulate short-term rentals in Athens-Clarke County. Since that time, we've been operating under that ordinance and we've been implementing the requirements of that. And it has been discovered and advised that we have some amendments that would help address concerns raised and some of the practical issues that have come out of the administration of that existing ordinance. So cover memo helps explain those hopefully succinctly because there's a lot of words behind the cover memo. 3 items. First item, addressing the definition of parcel as it relates to short-term rental uses. Why does that matter? We have, as a community, the administration of the zoning code, we've looked at parcels as splits of actual property, the division of the land itself. And in the management of the ordinance, what came to light was there's also another legal definition that looks at tax parcel. And with regard to short-term rentals, we have standards that say you can have one per parcel, and all it says is parcel. So what this does is it goes a little deeper and says relates to tax parcel. So in the case of a single-family neighborhood, each of those lots is a tax parcel, but it's also, from a staff standpoint, a parcel of land. Where this gets a little more interesting is as it relates to condominium developments, for example, where you might have a single division of the land and there could be several condominiums on that single parcel that are each a tax parcel unto themselves. So this text amendment would make it possible for those individual units to become eligible for a short-term rental, a single short-term rental. Okay. Second point, extending the sunset period for the legal non-conforming short-term rentals to 5 years from the 2 years that was adopted with the code in February last year. And this would also add what's proposed in front of you would also add a relief valve in the form of some math that would allow for a short-term rental operator to make application and request consideration for that 5 years to be reconsidered in order to recoup investment. And what we've looked at and what we've put together is a standardized way to look at what that investment actually is. After I introduce these, I'm going to ask for legal counsel to dig into why that's important. It's very interesting why it's important. Third point is short-term rental notification requirements. The wording that's in there now creates a requirement that frankly lacked a little bit of definition on who is to do what, let adjacent property owners know that a short-term rental is operating. And it also was a very broad umbrella for that notification. This kind of gives that a little more structure. It puts the requirement with the short-term operator to complete that requirement. And as I said, it kind of reins in the amount of notification that is to take place. So those are the three big ticket items that these text amendments are dealing with. None of the whereas statements from the prior adoption are altered. But John, I may hand it off to you to speak to nuts and bolts.
Sure. And I think you did a great job kind of explaining the basics, Bruce. So I won't go too much deeper than I necessarily need to. But as Bruce explained, I know it's 16 pages, I believe, if I remember how long it is. So it's a lot. But Bruce did a great summary. There are three major things that this addresses. And so the first thing is the definition of parcel thing that Bruce described. And as Bruce mentioned, probably a lot of us understand this. If you have a condominium complex, each one of those condominium units is a separate tax parcel. And so basically in certain zoning districts, it says that for the purposes of short-term rentals, parcel equals tax parcel. In terms of the sunset provision, what people call the sunset provision, that's the 2 years for legal nonconformings. It extends it to 5. And I do just want to kind of reemphasize that applies specifically to legal nonconforming short-term rentals. So I know we talked a lot about short-term rentals that are home occupation or commercial that maybe go through the plans process if they're commercial, or maybe even the special use process. I know we had a special use come through a few months ago, or somebody goes out and gets a home occup permit to operate a short-term rental out of their residence. Those are all conforming. And I think those would be the majority of the short-term rentals in Athens-Clarke County, if I recall correctly. Isn't that?
That are legal nonconforming would be the majority?
No, are the conforming the majority or do we know at this point?
Well, we're getting a handle on that.
Okay, yeah, okay. So, but we do know how many legal nonconforming we have. We've published the official legal nonconforming list at this point. So it's those short-term rentals that are on that list that would be impacted by these changes, in those specific short-term rentals. And so, as Bruce mentioned, it extends that sunset period for 5 years. It also adds what has been referred to as a relief valve. And what the relief valve is an administrative process that gives a short-term rental operator an opportunity to say, hey, understand I have 5 years from the date that the official legal non-conforming list was issued to operate my short-term rental as a legal non-conforming short-term rental. And, I need a little bit more time to recoup my investment in this short-term rental. Can I have a little bit more time? And so what the relief valve is, it's an administrative process for people to be able to seek additional time to try to recoup their investment. It is very math-based. That's because it's based on appraisal methods to help us determine whether they, credibly need additional time to recoup that investment. And Bruce mentioned some other changes too, things like the notification provision. As staff have begun to work with this ordinance, and this happens when you have such a new and comprehensive thing come in, you're going to find things that maybe you could do a little bit better or tweak. And so things like the notification provision in the ordinance is one of the things that I think staff found, hey, this could use some tweaks and clarification both for staff and for people who operate short-term rentals, so everybody knows what they need to do on that piece. So those are some of the big things associated with that. And, we're here to help answer questions where we can.
Anticipating that there may be questions from the math-minded among us about how that relief valve may work. With the assistance of counsel, there were 2 examples that we pulled together for hypotheticals for a rental. And that is pink and the yellow sitting in front of you. You want to take a minute and look at that? I may ask Thomas Mitchell to come up and walk through example 1 and then kind of show how it deviates where the changes are for example number 2. Okay, so number 1 is the goldenrod sheet.
If y'all are looking at this, if you're trying to figure out the difference, I'll explain the difference. But the only real difference is the cash flow and the stabilized yield. Those are everything else in this is the same. So I'll walk through number 1. There'll be forms. First of all, the way that this will have to be done by application. And what the ordinance says is that no later than 180 days before the non-conforming use would expire, they have to make this application. They can't do it any earlier than 24 months after the list was published. So it includes people from applying too early. You want to make sure you've got some realistic data to rely on, but you don't want them to wait till the very end because there's a process involved and the administrative hearing officer's got to make time for hearing. And you want to try to get that done before that 60 months is up. So there'll be some forms that the department creates and there'll be in the applicant it'll be just kind of like a taxes. They'll provide the information, then they'll sign under penalty of perjury that the information is accurate. So it's not a situation where you're happily put in a position where they have to suddenly become auditors or accountants. To a certain extent, you're relying on and if it turns out they're lying, then there's consequences for that if it turns out that they're being untruthful with the government. So there'll be a form that creates that shows what the cash flow will be after debt service and there's terms that you see there so they should provide the government with 3 years of that financial data. And then then basically the staff will determine kind of what it looks like and they'll reconcile those 3 figures. And that 58,000 on the example number 1 is not exactly an average. but it's close to the average of the previous three, probably with closer to the most recent year's data. Then they'll give us the purchase price. That actually can be confirmed because most people know vesting deeds in the state of Georgia, or the PT 61s require you to put that on there now, as long as it's a net and transaction. Otherwise, again, it'll be on the form that they sign. What the ordinance refers to as the equity basis in purchase is basically your down payment. This assumes a 20% down payment. That is oftentimes the very least you can do with a commercial purchase. Purchase date of May 1, effective date of the analysis is January 1, 2025. Those dates are plugged in just to create the timeframes that we're looking at. So from the date of purchase to the effective date of the analysis, year since acquisition, rounded down to the nearest half year is 3.5. The annual compounding rate of appreciation is established by the ordinance at 4%. So that it's, I mean, that may be one of the things that if you wind up in this, if one of these owners actually appeals this, that may be a point where things get discussed, or there has to be some proof, but at least by ordinance, that's set at 4%. So when you first get to the real math problem is in the next line. And what I've done with this is I've taken the language from the ordinance and put it in the footnote, giving you the citation to where in the ordinance that formula is, and then I put the figures there that would fit within the formula for that particular piece here. So for instance, the value of the real estate only as of the effective date, so January 1, 2025, you got the purchase price times, and that's kind of the appreciation rate to a power that is the year since acquisition. And so that's where you get that 516, 213 figure on this particular chart. Closing cost, again, were assumed to be, those are also set by the ordinance, aren't they? The closing costs, aren't they assumed to be 4%?
Yes, sir.
Okay.
That's the built-in presumption in the ordinance, but they can present information that alters that.
So then, and again, oftentimes if you're buying a piece of property for these types of business, for these types of operations, there's going to be some sort of capital improvements, and you want to give them the benefit of that. Usually STRs, short-term rentals, Airbnbs, those types of things are almost always furnished to some degree or another. So you've got again, there'll be schedules that are created by the department that provide a figure for the depreciated cost of the furniture, fixtures, and equipment. And then we get to another math problem. And again, in the notes, I give you where that formula is in the ordinance, the words of that, and then I take the figures that are on this particular example and do the math. And so that amount, the cost basis with real estate appreciation is 246, 713 for this example. So and again, oftentimes these things will be purchased, but then they won't be used as short-term rentals for a period of time, either because there has to be renovations or furnishing, or just because there was a delay. So you figure out what date they actually started operating. And then then you get another math problem. It's the normalized yield, and what that is. It's going to be that cash flow figure divided by the total cost basis with the real estate appreciation. So it's that figure at the top, which is their cash flow after debt service, divided by that figure that was just calculated, which is their cost basis. And that gives you basically their implied stabilized yield. And so what that is basically, if this is an investment piece of property, that's basically that's the figure that determines what this particular piece of property is yielding on a yearly basis. And then that's how you determine whether or not, how long it takes them to recover the investment they made. And again, it's a math problem. This particular one yields that given that cash flow, that purchase price, the basis that the owner has and the appreciation assumed, that it's going to take them 4.25 years to recoup that investment with that particular yield. And then because they have, at this point in time, they're 3 years into the non-conforming use. So how much longer beyond this period of time do they have to recover that, recover their investment? It's 1.5 years. That takes them to, in this example, to July of 2026. So they would not be entitled to any relief under the relief valve because that date is simply before the March 1, 2030 date that these non-conforming uses sunset. I'm not going to go through the same detail on the second example. That example just shows one where, and it shows that where the variables, I only changed one of the variables on this one to show you how the math can change. And all we changed was either because this particular person didn't market it as well, or didn't use it as much, or some other problem. They just didn't make as much money. But given the way that this particular thing operates, they would there's a presumption that they're still entitled to recoup their investment in some form or fashion. So you go through the same math exercise. Given that kind of revenue, stabilized yield revenue, it's going to take them almost 10.5 years to recoup their investment. And so they would be entitled to, assuming they could prove everything that they claimed, they would get 2 years of relief, which would allow them to continue to operate until July of 2032. That would be done by either the administration, the staff determined that and agreed with it. If the staff were to determine that there was some issue with it and deny the request for relief, then they would have the opportunity to go before the administrative hearing officer. And it would be like any other hearing where parties would have expert witnesses, and they would have to prove the facts on which they're relying. The unified government would explain why the staff would defend why they had denied the relief. And the result would be what the result was. If they didn't like the result they got there, then they could appeal it to Superior Court.
Before we do questions, could you also explain why it's helpful to have this in an ordinance and rather than in a procedure document or a policy document?
Sure. You want to do that, or you want me to?
Sure, you can go ahead.
Okay. So the thought is that having it in the ordinance rather than Bruce's staff just trying to do it as an administrative matter gave it the force and effect of law. And we put in plus by John drafting the ordinance the way he did and putting that formula in there, there's no question. It's in writing. It'll be adopted by the mayor and commission, and staff will follow the same formula every single time. And then the folks who are on that list who may feel like they're entitled to this kind of relief, they know what the rules are, what they've got to submit, and it's not. It reduces the pressure on staff, and it basically sets the ground level for everybody.
And one thing to remember, Thomas said this earlier, but just to reemphasize, there's certainly going to be spreadsheets and things like that staff can use to do these calculations. So Thomas did a wonderful job kind of breaking it down on that piece of paper, but I mean, they'll have forms to help them with this. And there'll be forms to help anybody who's on the legal non-conforming list who wants to make this application to know what to submit and those sorts of things too. So, you know, this is ordinance, but understand there'll be forms that come behind that kind of help from an administrative standpoint.
I do have one question. Thomas, you said that about 10 lines down, the annual compounding rate of appreciation line, it's set at 4%. And you said that that's set in the ordinance, but the ordinance says, at least the version I have, is step 5 is on page 8 of our handout. Step 5 is determine the annual compounding rate for appreciation of properties in the immediate area or neighborhood. So it sounds like that's a case by case determination, not 4%.
Yeah, and you're right. I misspoke. The one that the closing cost was the one that was established by ordinance. So yeah, that data. My understanding is that that some of the real estate documents, and there's ways to determine that. There's professional matrices that provide that kind of information for a particular locale. That's one point where I'm glad you asked that and had me clarify, because I did misspeak to that. That may be one point where there's going to be some discussion with regard to these applications. So my guess is that there'll be some coordination between planning staff, probably the financial department here at Athens-Clarke County, and then perhaps with the law department as to what an appropriate figure for that is.
What we had discussed was using tax assessor's office data for the parcel itself. And that removes any ambiguity about how we're defining the affected area or the neighborhood. We would actually look at the assessed value and how it has appreciated over time, and that's inarguable. And it's available to the property owner to also readily have without an expense of having an appraiser work.
Right. That does seem like, there's always room for people to dispute about what the immediate area or neighborhood is. And depending on where you draw those lines, the appreciation could be very different. And
Whose comps are
so, right. Whereas the tax assessor thing is effective and everybody knows what it is. When you say there's discussion of that, is that something that would not be in the ordinance, but would be in kind of the staff's process? Or is that something that you intend to change in the ordinance?
Well, it's my understanding that there are aspects of this that can be developed by staff and just made standard. And that would be the approach that we're suggesting with that step 5, is that we would use tax assessor's office data.
And so in the planning department has some administrative authority to issue, first of all the forms we're talking about, but also written policies as well for this. So that might be included. I think what Bruce is saying, that might be included as part of a written policy.
That makes sense. I guess, looking at step 5, I see 8 words that could be deleted that might just help in that regard. If we changed it to say, determine the annual compounding rate for the appreciation of, and then delete properties in the immediate area or neighborhood for. So it just says the appreciation of the property at issue. Just so that an applicant who's trying to get more time can't argue that staff using the tax assessor data is violating this neighborhood language that's in the ordinance. Would that be?
I'm trying to remember some of the discussion that we've had regarding that, if there was some particular.
I suppose there could be a time when you've got a neighborhood that's going through a change, or somebody who has bought a piece of property that was depressed, and in that where the tax records may not necessarily tell an appropriate story. So I can anticipate a time when when to be fair to the property owner, it may be better for the staff to have the right to look at other properties or other trends in the area and not just that particular property.
I wonder if there'd be some value in saying, determine the annual compounding rate for the appreciation of the property or properties in the immediate area or neighborhood as may be applicable or something like that, just to your point, Thomas.
Yeah.
Would it be helpful to make that more specific, to say that, in the event that data is not available or is, where I'm trying to go with this is if the data has grown stale on a particular property, then the check down is you can do the surrounding area. If you have robust data for the parcel, then you stick with that.
Yeah, you could just say the rate of appreciation for the property, which shall presumptively be the tax assessor value. But that's a rebuttable presumption that the applicant can say, look at all my evidence. You need to use a different number here.
And the other issue there
That would give staff leeway.
The other issue there was if somebody had appealed their tax, their assessment, then if that number is resolved, in litigation, then there's a 3-year lock-in, and so they wouldn't see any increase for 3 years.
Yeah, tax assessor's data. So there are some things from a tax, either an appeal perspective, and I know there's some new laws coming in on that are going to impact everybody too. It may be, I certainly understand the comment about using tax appraiser data, and I think that, maybe we can. I guess the other thing too, to your point, Thomas, is what if there is a rapid change in the neighborhood or something like that? There may be some data that's more relevant than what you could find necessarily on the tax assessor's website.
You mean if the neighborhood's changed a lot and so the tax assessor undervalued the relevant part? If somebody's really improved it to make it a short-term rental and make it nice, and the tax assessor has followed that so that the property has risen much quicker than the surrounding neighborhood, then I take it we'd want to capture that.
Mhm.
But you're saying maybe the tax assessor won't have caught up with the reality on the ground that the property has gotten.
Maybe so. I think that's kind of what.
Yeah, because with the way the tax assessor, the data, you're already a year behind when you're looking at the data, because all that's looking to the past.
Yeah, it's obviously imperfect. I'm just saying, like, the way it's written now, it's super contestable. So every single appeal is going to be, people are going to have grounds to argue with staff about it. And I think clarity and simplicity, even if it's imperfect, it's simple and thus less contestable and less prone to litigation and stuff.
I think as long, my view is John and Austin will have to weigh in on this, but my view, because of the ordinance as a whole gives the planning director the authority to interpret. As long as he were to put his interpretation in writing, that would be, it's not going to have the force and effect of law, and it can still be a point of discussion. But if staff puts in writing, either on one of the forms or in a written policy with regard to this thing, that the department will look at tax records first, and that will be the presumptive data that they will use, subject to consideration of other appropriate data or something like that, so that it's clear to everybody who picks up that form, we're going to start with the tax assessor's data on this, unless there's a good reason not to. And that way, if something, again, Bruce talked a bit about the challenges of administration, we're fixing the parcel definition, for example. That'll give some flexibility on this as they administer this, so that we don't have to, the government doesn't have to come back asking for amendments to the ordinance every time there may be an issue or they change the tax laws or something like that.
No, that makes some sense to me, Thomas. I think understanding that the department does have some flexibility as long as it's in the form or written policy. To be able to address that step number 5. To the points that Matt's raising.
We have public comment? Are we like, I'm not
No,
sure where you're at.
I was gonna ask.
Yeah, I was just asking a question during the staff presentation, but I don't think is the staff presentation concluded? Because then we can turn over to public comment and then.
Unless you have questions.
The financial questions, I can pull them back up later.
Yeah, we can pull it back up later for stuff like that. All right, that was the staff report. Is there any member of the public here wishing to speak to the short-term rental text amendment? Step right up to the book.
Good evening, Commissioners. Joey Tucker, Yankee Valleywood Drive. Sat in your seat for several years, so I know exactly what you're going through. I'm here to speak on the 3 issues, but short-term rental overall. Number 1, the issue that you're looking at as far as tax parcel, that is needed. We need to look at that. We need to make sure we're doing that right to allow properties that are conforming and that can be used as short-term rental. Those should be looked at and approved as they are standing. Item number 2, extending 2 to 5 years. I'm asking you to take out the 5 years altogether. We don't have to have the 5 years. I'm asking you as commissioners, you're also citizens of Athens. And you're also here to represent citizens all over Athens and do what's best for the entire community. You're not elected, you're appointed, and so therefore you have a responsibility to make sure we're protecting private property rights and citizens in Athens to do what they choose to do with their property. I'm asking you, you've got a formula in front of you, and how many have seen these yellow and pink, the yellow and pink paper before tonight? So you've got presented this to look at it, to let an attorney determine value of property, for you to make a decision tonight and determine what's the best use for the citizens of Athens. I ask you to table that, and don't even look at that. I don't think that formula is properly, should be put in there. You need to have more time to look at that. You need to review that. I know if I was a commissioner sitting behind this rail and having very little time to review that, I would not be happy with what's been presented at this time. So I ask you to take a look at that and consider not moving forward with anything there with any kind of formula. I look at the notifying people within a 300 feet or a certain boundary of the property. Why? I don't think this should be required, because if code enforcement's doing their job, then why do we need to notify the people around us of what is being used with that property? That is your private property right. If there's a rental property there, then they should have the right to have it as a rental property. Because at the end of the day, these people are there living, they're there sleeping, eating, just carrying on their life. And so why do we need rental property? You know, I challenge you, do you know that 30% of the hotel motel tax is short-term rental? And that's from our CBB here in Athens. It's 30% tax of the hotel motel tax. And why is that important that you need to know? Because we need to address short-term rental in Athens. We need it. Why do we need it? Because we have medical here. We have UCBC that is incredible in Athens, and it is bringing people in. If you have cancer or any kind of treatment you need, and I know from experience of recent that you don't want to be in hotels walking around. Do we have enough hotels for our new Classic Center Arena? No, we don't. We don't have enough hotel rooms. We don't have enough places to put people. We don't have people who are having to stay out. Do we have enough hotel for our new hockey team that we're excited that's playing in that arena, and not just the concerts that's coming? What about the religious meetings that happen at our Classic Center? 6,000 people come for the Methodist. Do we have enough hotel rooms for that? No. Do we start to look at our film industry that we're excited that's now coming to Athens? Do we have enough places to put people? We don't. Are we going to look at family events, weddings, funerals, reunions that all bring people to our town, that we're a tourist town? No, we don't have. I haven't even touched that major thing that sits here in downtown that connects to us. I haven't even spoken about that. But why do most people live in Athens? Because of the University of Georgia. So we need to look at that as well. We have sporting events. We have other things that do that. So I know my time is cut short. I will leave you with this. Rental registries are illegal. I've said that before. I've said that behind the rail. Official Code of Georgia 367430B says any rental registration is illegal. Having any kind of list for rental registration is illegal. So I ask you to remove that as well.
Thank you, Mr. Tucker. Is there any other member of the public here wishing to speak on this text amendment?
I will point out, I'm the president of the Athens Board of Realtors, and I was speaking on behalf of Realtor Association.
Thank you.
Good evening. How y'all doing? I appreciate everything y'all do for Athens-Clarke County, because this is a thankless job, and I appreciate it. Let me see.
Can you identify yourself?
I'm sorry. Yeah, I'm Charlie Upchurch, and I live at 145 Tillman Lane. Also run a real estate company, Coldwell Banker Upchurch Realty. And just to share a little bit about me, you know, I believe in supporting government that has common sense. It's all about common sense. It's very important to me, and the way I run my business. I try to think of things in every light, but as well as that, being a realtor, I also, one of the things that we support is private property rights, just as Joey was saying, and I'm speaking on my behalf. But I believe in private property rights. And like he stated that, you know, I believe in the first issue that y'all are voting on, that we do need to have some kind of proper way to identify the properties. That needs to be passed. I also remember back in the day, speaking out against no more than two unrelated. when Athens-Clarke County put that into effect. Nothing that, and now we don't even, you know, I don't even think they enforce that at all anymore. But it's still on the books. So what they did there was back in the day, you know, men were building their retirement portfolio for their wives. When something happened to them, they wanted their wives to have the retirement the portfolio, the rental portfolio for their retirement. We did away with that in a lot of cases. And so this is kind of the same way here too, is that, you know, they're making a living off these rental incomes. All right, so I think 2 years ago, maybe 3 years ago, in Glenwood, there was a house that had, you know, 18 people in it. That's a problem. I've got a problem with that. That's not right. Why don't we do an ordinance to where you say, you know, no more than 2 persons per bedroom, maximum, you know, and then that's it. Everybody can do it. But we've got code enforcers that are supposed to be following up on this. We're supposed to have things that mandate how you run your business. Let's enforce those. If I live in my neighborhood and I can't have a rental, Airbnb in my neighborhood, but across the road, that subdivision, they can. Why is that right? That's not right. That's taking away the property rights from those people over there, just, you know, as we leave here. That's not right. There are things we can put into effect that implement this, or that would make it where we can police this properly, and it's fair to everybody. Not everybody wants to have a Airbnb. Not everybody wants that, but they are needed. And to say, you know, hey, look, we're going to make the decision that your subdivision can't have it, but this one over here can, that's not right. It's just purely not right. So on the second item that y'all will be voting on tonight, the sunset law, I want that abolished. I don't think y'all ought to pass that. I don't mind y'all putting some stipulations in there, but we need to think about them, what they're going to be. You can make this work. I don't have a problem with y'all, you know, figuring out how to make it work, but you can't make it. You got to make it work for everybody. You can't make it work for certain people. Let me see what else. Again, like Joey said, we got Twilight criteria coming in here. We've got Athens half marathon, all these different type things we're promoting. But, you know, go stay in Jackson County. Go stay in the hotels in Oconee County or any other place. And there also needs to be a way that you can tax this. That y'all are smart people. Y'all can figure it out. But people that are doing this and generating money off of it, they ought to pay taxes on it. And that's the problem I have right now, is they need to be taxes, just like the hotels do. Thank you.
Thank you, Mr. Upchurch. Is there any other member of the public wishing to speak?
Good evening, ladies and gentlemen. I'm Linda Carroll Porterfield. I live at 1020 Chestnut Glen, Athens, Georgia. And I want to speak personally on my behalf, and I want to tell you a reason why I think they're a very good thing. This is from personal experience. A couple of years ago, my son's in-laws passed away, and some of you in this room know them. It was Ray and Joan Nicholson. Mr. Ray was the county attorney here for many years, and his son John wanted to come and have a memorial service here for his parents who had moved away. John had moved away, and he wanted to have a family gathering here in Athens. He rented 2 short-term rental homes in Athens to have a big family gathering for the memorial. He didn't want to have it in a hotel. He wanted to have it in homes because he wanted to have family gather where they could get together, they could memorialize his parents. It was a very intimate thing, and it was beautiful. And he rented 2 large homes in Athens. I think that is a perfect example of why hotels are not for everybody and every occasion. As Joey alluded to, I had cancer one time. When you have cancer treatments, I happen to live here, but people come here from all over, and you know they do, for cancer treatments. They don't want to be in a hotel. They want to be in a very quiet, secluded area. I want you to think about those things, ladies and gentlemen, and I agree, y'all have a very thankless job, and I appreciate what you do. But there are a couple of things that I noted while the presentation was going on. That's a very cumbersome process. People should not have to do that. As far as I'm concerned, I'm here for private property rights. And in Georgia, as Joey pointed out, rental registration is against the law. I'm concerned for any county, any government that would make any kind of rental registration that violates the law. And that is my conclusion. Thank you very much for your time.
Thank you, Ms. Porterfield. Is there any other member of the public here wishing to speak?
Good afternoon, evening, ladies and gentlemen. My name is Brandon Smith, and I'm a resident of 196 Fortson Circle here in Athens, Georgia. My wife and I have operated several short-term rentals successful here in Athens for 4 to 5 years. I would be one of the legal non-conforming individuals that you guys spoke of earlier. When considering this body and the planning commission, or the main commission of mayors, when you guys were discussing this ordinance, I understand the right for county commissioners and this board to enact regulations on short-term rentals. They can do that from this day forward, or from the time that the language was passed forward. The issue that I have, I think many people have, is the elimination of the grandfather. In lieu of what was proposed to be a 2-year sunset, now I'm hearing it may be 5 years. My wife, like I said, we've operated this short-term rental. We live a mile within it. We've not had an incident in the 4 to 5 years that we've been operating. We have been operating with a Athens-Clarke County occupational tax permit this entire time. When I know many don't, we did. We're very particular about who we host. Absolutely do not tolerate any types of parties or nuisance behaviors from any of our guests. All of our neighbors, whom we know personally, have never complained. We pour tens of thousands of dollars into this property to create the best experience possible for visitors to Athens. My wife and I have based our retirement plan on this property with this use. In the long term, having our property rights infringed on will be devastating to us financially. Not to mention, this proposed bill will likely not withstand court challenges, according to our own county attorney last February. I believe this violates my constitutional rights, the takings clause, not being offered anything for a use that was permitted, and that I paid Athens-Clarke County for a permit every year I was operating. I'm not against prohibiting short-term rentals from operating in single-family residential areas in town, new short-term rentals. With the new proposed regulations and the process that will be put in place, it was supposed to deal with the bad apples and not the good apples. We feel like we definitely fall into the category of the good apples. But the way that this is being targeted, that's not what's happening. A lot of good apples are being caught up in this attempt to drive out a few bad apples. Voting for the language to eliminate the 5-year cap, I would ask you to consider that, and to allow for the grandfathering of legal non-conforming properties that exist and are operating in good standing in Clarke County. You have ordinances on the books. Thank you all for listening to me.
Is there any other member of the public wishing to speak? Text amendment.
Good evening. Joe Silva, 133 Valleywood Drive in Homewood Hills in Athens, Georgia. My point's very short. Approved short-term rentals should be allowed to transfer with the sale of the property and not die. This protects existing property rights and supports fair and consistent expectations for both current and future homeowners.
Thank you, Mr. Silva. Is there any other member of the public here wishing to speak on that?
David Ellison, 2500 Danielsbridge Road. I clearly have a lot of objections with this ordinance in general, but the one issue of what we ought to focus on is this relief valve. As a general rule, those jurisdictions that have authorized a amortization process for this is looked at some sort of financial or accounting standards. I've suggested that a reasonable standard, if we're going to go this route, is 27.5 years, because that's what the IRS uses for depreciation schedule. I think there are some other standards that could be considered as well. My concern here with this formula is that I'm not aware of any accounting or business professional that would use this formula. I don't think this is what the marketplace does. And so that's why I believe that this formula, as it stands, I have serious doubts as to its validity. And I would like for y'all to consider questioning how this was determined, how, marketplaces, other jurisdictions have used this. It really reflects what a willing buyer, willing seller would use. Also draw to your attention, subsection 3, at the end of the formula. And it says the standard methodology is developed to address almost all situations, and deviations are permitted when it's established under competent evidence that a particular application presents unique circumstances not otherwise contemplated by this standard methodology. And my concern is I think that in many ways there needs to be a relief valve from the relief valve. And I don't think this is very vague. This focuses on what are the standards, what is the circumstances being contemplated by this methodology? With this methodology, it doesn't actually reflect the market. And then you're dealing with a situation where you're not actually challenging the validity of the formula. You're trying to prove whether or not your particular STR is unique. I know that in some circumstances, some jurisdictions have an impact fee where you can have an alternative calculation. You can show, hey, my property does not fit within your standard impact fee calculation. I'm going to do my own route. Say, this is why I think, this is what the fee should be here. In this circumstance, there should be some language in the ordinance that allows at least some sort of independent study where someone can show that the property is not necessarily unique. It's just that this formula is wrong. And if you don't consider that, there's going to be a challenge and ultimately the whole ordinance could get blown up. So thank you for your time.
Thank you, Mr. Ellison. Is there any other member of the public here wishing to speak on this text amendment? All right, seeing none, we will bring it back on the rail. Who wants to start us off? Alex.
Can I have, is it Thomas? Would you mind answering a quick question for me? So, and I'm going to have other questions, but for you, looking at the formulas and things, where are I used to sell companies, so I love a P&L, but I'm not seeing maintenance cost. Is that captured up top?
Those
Cash flow?
Okay. Cleaning, maintenance, lawn care, that's all going to be captured in that.
Okay, so it's going to be captured up top.
Yes, sir.
Okay, good. So it's true cash flow there. And then management costs and all of that. And okay, that's the main thing I had. Thank you.
So how did you come up with this formula? And is this a formula that's being used in other areas where short-term rental is an issue?
I don't know that this particular formula is being used in any other jurisdiction. The focus of this formula was to address some arguments made by some owners. You've heard of some of it tonight about the ordinance takes property rights and for there to be a regulatory taking, you basically have to interfere with investment expectations. And so this formula is designed to address that particular prong of an argument about regulatory takings.
So do you know in other areas where short-term rental ordinances are in existence, if there are formulas, not this formula, formulas in general that function in the same manner, like a relief valve? Are there sunset periods in other areas that we can look to for a precedent?
The sunsets I'm familiar with don't permit any relief. The ones I'm familiar with, isn't that right?
From what I've seen in the past, I'm not aware of one that has something similar to this for a sunset.
In the areas where sunset clauses do exist, has there been any successful pushback legally from any residents as far as has there been litigation?
There are reported cases from all over the country about people contesting sunset provisions. And as Thomas mentioned, a lot of times it deals with the regulatory taking aspect of that sunset provision and whether people are able to basically recoup their impact expectation. This does two things. First, it extends that sunset period from 2 to 5 years to partially address that. And then as an additional measure, it gives that administrative process, again, like we discussed, for people who may say, hey, I need more time to recoup my investment. Gives them a method to do that.
Going back 50 years, there's the earliest cases I saw, I think about go back to the 50s, and it's different industries. I mean, junkyards, apartment complex, I mean, all sorts of different types of use that's been sunsetted by various jurisdictions across.
Thomas, can I just ask you to speak louder?
I'm sorry.
Make sure the mics are picking it up, and I'm seeing some people behind you putting their hands up to their ear.
So this concept of sunsetting non-conforming uses has been applied across all types of property uses, from things like junkyards to apartment complexes to cleaners in some large cities, things like that. And of varying times. I mean, we've seen them as short as 90 days and as long as 8 years. So it's not uncommon to have these sunsets, and there's a number of reported cases, but so that's what this formula is trying to address.
And it's true, isn't it, that Clarke County, when we passed the family definition ordinance, however many years ago that was, that made it so that you can't have more than 2 unrelated people living in a house in a single family zone neighborhood. Was there any sunset provision or?
It was based on conveyance, as I remember, which is it was very similar to the language that was originally presented on the short-term rental ordinance last year, where it was really based upon conveyances. I don't believe there was any sort of particular year measurement.
What you may be remembering is in 2000, when the entire county was rezoned, there used to be a zoning classification called RG, general residential, that allowed for duplexes. And the commission decided to remove that from the code at that time. And so the provision was put into what was called RG grandfathering, which was a 5-year period that allowed for that property right to continue for a 5-year period, if that's what you're thinking of.
That's not what I'm thinking of. I'm thinking of the definition of family, which I believe specifically says there's no grandfathering for, maybe it was, you had a year or 2 or something, but there were a lot of single family homes that were rented to students, and then they were not legally permitted to be. And my recollection is that it was a very short period of time in which that transition occurred. I guess it's in 9-15-18.
15?
9-15-18.
Indeed, a non-conforming use created by the definition of family adopted June 5, 2001. That section?
Yeah. Shall be permitted to continue through July 31, 2002. So that was a 1-year sunsetting. So, and that was not challenged, or at least was not successfully challenged as a taking in the courts, right? Courts.
My understanding was there was a single challenge of that, and it was not successful.
Okay, thank you.
One more question about the legality of rent registries.
I'm actually litigating that issue with Mr. Ellison, and he's filed a brief saying we have filed a brief saying that particular statute doesn't apply to these. This is not something where the government has required these people to do this. I mean, if you're going to put your name on the STR list, you've done it voluntarily. You don't have to do it, and it doesn't require the same type of information that statute discusses. And that particular statute, I think that applies obviously to apartments and long-term lease properties, not Airbnbs and VRBs.
Does it specifically? Just a second, Alex. I'm so sorry. Next.
I don't have a question. You can finish up if.
Okay, then go ahead.
I was just drawing in and chatting about it, but does it specifically give a number of days when you said that the state law is for more long-term? Does it
Does it say 31 days plus or?
I'm relying on an industry standard of, or kind of what you see in a lot of ordinances of things less than 30 days and then think more than 31 days or more. That, I mean, the statute itself does not address it.
Okay.
Doesn't define it.
Okay, thank you. We have more questions. Call you back up. So Kristen, next.
Yeah, so just some general comments. So one thing, I actually do like the notification portion of this. I mean, bottom line is this is a business that's being operated. I mean, you are renting out a space and someone is paying you for it. And in places where people are living full time, presumably next door to a business, I think they have a right to know that. So, I mean, there's some talk of private property rights, and yes, like you can have private property rights and the other person next to you can also have their private property rights. So like, we're all here to talk about how we're making this fair for everyone. And so I have zero issues with the notification. I'll be honest, all this discussion about, I mean, what is it, like 9 or 10 pages of this ordinance is to math problems. Bless y'all's hearts for coming up with the math problems. Like y'all need a couple gold stars. But I was here when we first went through this, and I remember distinctly how the sunset clause got proposed. And we were coming out of the pandemic. This was a hot issue. We were hot on this, and like I understand it. We also took a big risk because there was a chance that it wasn't going to pass the Mayor Commission with that sunset clause. And it passed, but like, I understand, like, I feel like hindsight's 20/20. Like, in retrospect, is it worth the trouble of putting the sunset clause in for what gain, right? Like, and I say that the context for me is like, my house is a duplex in a single family neighborhood. And today, by our zoning standards, you technically would have to get like a special permit to build this house. Like it wouldn't be allowed today, but now it's grandfathered in because it's there, it exists, it's part of the neighborhood. And so I feel like it's a bit of the same argument for folks who started when it was the Wild West and anybody could start an Airbnb, and ACC was late to adopt some regulations on it. So kudos to them for like going out and getting it. But now we do have some regulations. So like my take on this is like, okay, so you started your business, and if you are grandfathered in, you're grandfathered in. And going forward, now we have these rules in place and now you have to abide by them for new ones. So I just feel like I would feel a lot more comfortable. I also don't want this to go back to the Mayor and Commission and we lose the whole thing. That's kind of my main, like, I think it's very important that we have regulation for short-term rentals. And I would hate to send something to the Mayor and Commission that just doesn't pass muster, period. So my proposal would be to just strike the 5-year grandfather sunset clause, and just send it forward without that portion.
Mike?
I have a different perspective, I think, because there are some bad apples out there. And I think the sunset clause was specifically to help address neighbors' concerns about these problem cases, because there are definitely problem cases. My neighborhood has one that advertises 35 beds. Regularly has school buses pull up, 20, 30 cars out front. And I know that, not me personally, I don't live near it, but the neighbors who live next door, constant complaints. It's a huge headache. So their only relief, relief valve for the neighborhood, they need the sunset clause. This needs to go away. It's very obviously a commercial operation in a residential area. And, I don't think that ever should have been allowed to take place. We heard a dentist's office not too long ago. If this was a dentist's office with just a trickle of cars, it wouldn't be allowed. But somehow, because it's some other type of business, it's allowed. And that doesn't seem right. It's a money-making enterprise. It's operated as an LLC. It's a business. It has cash flows. It's very obviously a business. And we have residential zoning to protect people from having to live next door to, was it essentially in my neighborhood, an event venue. We had a family reunion last weekend. There was over 50 people, like 20 cars, parked all over the place. So this is, by any other name, it's an event venue. And it has this regularly. There were school buses pulled up a couple weeks ago. And, I just don't see how there's any relief for the people that live next to these type of properties other than the sunset clause. Because this is very obviously, like I said, a commercial operation that should have never been allowed to take place in the first place. So I'm against any change of extending it to 5 years. I think 2 years is good, Or I think we need to, at least in lieu of that, because, there are tons of good ones. And I would like to see the good ones not have to be impacted. So in lieu of I would be more flexible and support if there was another type of relief valve for the neighborhood, like a maximum number that was suggested, like maybe 2 people per bedroom, or, a maximum of 4 cars, because there's regularly like 20 cars at this place. And, so until we have, neighborhood relief, I don't see the need for relief for just the people who own these, because it is an issue for the whole neighborhood, and it's not just about the people who own these, it's about their impact on the community. And I think that just giving so much to the people that own these is really kind of ignoring the other benefit, the other side of the equation, which is the people that have to live next to these event venues. So I think like the small ones, fine, let them go, but these bad apples can ruin it for everyone, and I think they have in this case. And unless we have a specific way to weed out the bad apples from the good ones, then I'm just against any sort of extension. I'm fine with the other ones, but the extension, I'm even okay with the relief valve, but changing that to 5 years is a huge jump, and I absolutely would not be in favor of getting rid of the sunset clause altogether, because I don't think, if I put a sign up that said Mike's B&B, I wouldn't be allowed to have that. So this is a hotel and it is a B&B, and just because it's got the name Air in front of it doesn't change it. So that's my 2 cents.
Thanks, Mike. I just wanted to clarify something. I think there's sort of a missing piece at the start of the presentation that I think would be helpful. And so please, can you all correct me if I'm wrong? Like, to my understanding, the way that the ordinance is written, there are certain short-term rentals that would not be restricted, like home occupancy short-term rentals. Is that right? They would not sunset if somebody wants to rent out their own home as an Airbnb. And I don't know what percentage of all the short-term rentals that is, but is it correct to say that there are some existing short-term rentals that would not be subject to any sunset, that would be allowed to continue under these regulations?
So I think there would be some short-term rentals that could be non-conforming that could become conforming. So, in that case, if they wanted to continue operating, they would just have to come up to the current code. So to your point, maybe get a home occ permit or something like that to become a home occupation short-term rental. So, again, the sunset only applies to legal non-conforming, and some of those can become conforming.
And what short-term rentals are conforming now? In certain zones, is it not the case that short-term rentals are conforming and so would not be subject to any 2-year or 5-year sunset?
That's correct, yes. And so that's kind of, and I kind of muddled that when I was talking about this with Bruce a little bit at the beginning, but there are certainly conforming short-term rentals, and those are either what is defined under the code as a commercial short-term rental that's gone through the plans review process, or if it needed to, got a special use permit. And then there are home occupation short-term rentals where the person goes and gets a home occ permit, just like they would for any other type of business, and they're allowed to operate under that permit. So, not every short-term rental in Athens-Clarke County would be impacted by this sunset clause or the relief valve. It's just those that would be legal non-conforming.
Okay, and do we have any ability to quantify based on the list that the list is just legal non-conforming? Do we also have a list or even numbers of how many are conforming, like currently operating STRs in Athens-Clarke County that are conforming?
Conforming in that they hold permits to operate. That's what that would mean.
Okay.
Is you're conforming because you hold a permit to do it legally by ordinance.
So they hold either a home occupancy permit, or is it a special use permit, or is there a?
Correct. Either by virtue of a home occupation, or an approved commercial short-term rental permit to operate. And some of those commercial short-term rentals have gone through a special use process to then be able to go get the permits from building inspection to be able to do the work to make it code compliant. So there are several that have done that, completed that process in the past year successfully.
Okay, so it's not a huge number though of existing STRs that are conforming.
I'm gonna ask Max, what's the number right now that we have that are compliant, permit holding short-term rentals
Roughly 100. Okay.
in a year?
Okay. So there are some short-term rentals that are conforming. The larger number is non-conforming, which means that they're currently subject to a 2-year sunset, and this proposal would extend that to 60 months across the board, so that every one of them would have 5 years from a date that's already happened, right? What's the?
March 1st.
So 2025?
Of 2025, yes, sir.
Okay.
So go from March 1st, 2025 to March 1st, 3030.
30, okay.
Or 2030, excuse me.
Okay. Yeah, we're not doing 1,000.
Yeah, not 1,000. 1,000.
Okay, so, and for those that would sunset, is it accurate to say that they can seek a special use permit to become conforming? So the sunset is not necessarily going to apply to all the ones that are legal non-conforming, because they have 5 years of runway and they could seek a special use permit to become conforming within that time period, right?
If they're
That's right. Yeah, you can kind of think of a Venn diagram, and you have legal non-conforming and then conforming, and there's a part where they're currently legal non-conforming, but they can become conforming through the ordinance. There are a few that are legal non-conforming that once that 5-year sunset ended, or 2-year sunset as it's currently written, because of the way the code is written, they would not be able to continue the business. There's no way they could come into conformance as the code is currently written.
So some of the ones that are legal non-conforming are eligible to become conforming, and that would just require action to seek a permit by the property owner. But some of them are ineligible to become.
To become conforming, to become a conforming.
Okay, sir. Okay, thank you. So I guess my other comment then is about the sunset provision. You know, I appreciate what some of the public commenters said about, you know, that STRs serve a valuable function, you know, that's not everybody wants to stay in a hotel for all purposes when they're traveling or visiting Clarke County. Some people need a family space where everybody can stay under one roof, and some people, you know, want to have a family reunion or weddings or you know, what have you. So I appreciate all that, and I thank the members of the public who came, but I think it's important to acknowledge that the origin story of this ordinance is not solely about stopping the 35-bedroom party house kind of thing. It's not only about bad apples. It is also about the effect on our housing supply and the effect on rents and house prices, right? Where everybody knows we're in the middle of an affordability crisis for housing, and to the extent that there are short-term rentals that used to be long-term rentals or used to be owner-occupied housing, the movement of those, transition of those units into short-term rentals has been good for the segment of the community that needs a short-term rental. It's been bad for the segment of the community that needs a place to live at an affordable rent, because it reduces our supply. And with the population growing, reduced supply means escalating prices. And so I just think it's important to recognize the sunset is not only about weeding out bad apples. That's certainly a relevant consideration, but it's also about bringing some of those units back into the long-term housing supply, which is just one of those classic kind of trade-offs that legislative bodies make. You know, there's good and bad on both sides of it. And I think that that's the judgment that our commission has already made, that we need to bring some of those units back into the long-term supply. So yeah, I think that I'm persuaded by the arguments. I mean, I take it that the reason that staff is suggesting extending the sunset from 24 months to 60 months is there's somebody who's like furnished a house for $10,000 or $20,000, put a bunch of furniture in there and bought towels and coffee makers and all the stuff you do to do a short-term rental, has invested a lot of money in it. They need time to earn that money back. And they may eventually transition the property into being a longer-term rental or sell it as they may choose. And that 5 years ensures that the vast majority of them will have recouped their investment with a substantial return. And so their investment-backed expectations in the language of the Supreme Court opinion about regulatory takings will not have been violated. And so I'm sympathetic to the notion of removing the likelihood of successful litigation against the whole ordinance by giving them 3 more years of runway to ensure that I think it's likely to be very difficult for somebody to demonstrate that they have not yet recouped, most people to demonstrate that they have not yet recouped their investment if they're given 5 years. So I'm sympathetic to that change. I think the other aspects of this seem pretty non-controversial. The tax parcel thing seems like an obvious, kind of a correction to make sure the ordinance says what it meant in the first place. So that in a condo development, there can be more than one, that makes perfect sense to me. And yeah, so I think all of this seems good. I'm still a little confused by the math formula, but I take it that there has been a significant amount of thought put into it. And, I might be persuaded, I'd like to hear what other people think about specifically the formula, but I might be persuaded that tabling this for a month so that we can look at the illustrations more and just kind of ask questions that we may have that we don't have today, but that we might have tomorrow could be a good idea. But, if everybody else is like, formula looks good, let's set it up to the mayor and commission and let them decide what they want to do. I could be persuaded that we don't need to hold it for a month. But anyway, those are my thoughts. And I see Mike saying.
I was going to add that, my main concern with extending the sunset clause does have to do with bad apples. And you're right, there are a lot of other considerations. And I have nothing against all the good apples out there. So I was wondering if there's any other sort of like neighbor relief valve that could be built in other than a sunset clause, something to do with like certain amount of code violations. You lose your, goes back to 2 years, or, even just to do away with 35 beds to do some sort of like 10-person maximum. That would really get me on board because that would, because like I said, I have nothing against the good ones. But I do think that we need some sort, like we can't just tell the people that live next to this event venue that there's just nothing that is just going to be there forever. Because I think that infringes on their property rights kind of, to an extreme degree. So, were any other considerations taken for neighbor relief valves other than the sunset clause? Could we do anything?
So I can speak to the occupancy number, and I can tell you that staff is currently working across 5 different departments. We've got fire code, we've got life safety code, we've got building code, we have zoning code, and then we have specifications that the finance department needs to work within. And we're trying to handle this administratively to set occupancy levels so that if somebody gets to a very high occupancy with their short-term rental, they're no longer functioning as a short-term rental. That's a different kind of use. And we're pulling from other code to make sure that we're doing that on a life safety basis, that we're not creating an unsafe condition. It's not just, we don't like this. There's a problem, and that problem is something that is unsafe and unregulated. So to the extent that I can address what we're going to ultimately end up with, the overcrowding kind of occupant load will still be subject to enforcement, but we will have clearly stated thresholds that all departments involved in enforcement are going to understand. And we're all going to work together to enforce those uniformly so that we're not guessing about when something becomes a boarding house and when it has remained a short-term rental. So I can speak to that, which is something that sort of cohesion on enforcement right now is new because this use didn't exist in the book. So now we're working together to figure that part out. As it relates to having recourse for a neighbor or, you know, somebody who may be offended by the use or aggrieved by it in some kind of way. There's two ways that we're approaching that. One is we're trying to set the standards up front for how to operate. So that you don't have to worry about guessing on how it's being used. Like we'll have documentation on what this person said that they're going to do and how they're going to use it. And that makes it much easier to see when somebody's deviated. And now we have something to issue warnings and potentially citations against. So that's helpful. The other side of it is creating sort of a clear sense of expectations about how enforcement's going to go, to the extent that a staff person's been dedicated to do just this, to just do short-term rental. And that person's in place. They are a seasoned employee. They're a longstanding code enforcement employee that kind of knows the ins and outs of how to take things through our judicial system. So I feel like we're in good shape moving forward. Key here is getting an ordinance that we can function within and then let the machine run. So,
I'm sorry.
Yeah.
I was gonna say, there's a reason why we can't put like an occupancy number in the ordinance.
is there a reason?
Like two people, like two people per bedroom kind of thing? Like just say like if it's a 4-bedroom house, you can have 8 people or 10 people.
So what we're trying to not have is kind of an arbitrary number. Something that's just sort of, this feels right, especially when we have so many other codes that have already established what is right from a safety standpoint. So we're starting from that. That's where staff is working right now.
It doesn't seem to me like Mike's proposal is arbitrary. Like if you said no more than 2 persons per bedroom or something like that. That doesn't sound arbitrary. That sounds like rationally related to a legitimate government regulatory purpose. 8 people in a 4-bedroom house, 4 people in a 2-bedroom apartment. That does seem like, to the extent that we wanted to, regulate
Numbers of cars.
bad apples.
Yeah, you could regulate numbers of cars, you could do that kind of thing too. Or.
We already do. We already have.
Yeah. Well, then there's like code violations and you might get a citation, but is there any real penalty, like if you pay citations and you're still just cranking through? Like what's the, like maybe the relief is like, you get like 5 citations and you're non-conforming. Because then if you're never getting citations, then, the good apples don't get affected, only the bad apples. And then that's not like an arbitrary neighbor complaining. That's a citation from the local government. So that's not just like, some NIMBY being like, I don't want it next door to me. That's, you've broken these established rules and there's consequences for that.
Can I add something?
Sure, go.
Do you mind, Mr. Chair? All right, so, and I've got other questions for later and I'll hand it back to you, but so I was on the board of the Taylor Grady House when it came from, when our foundation took it, after the junior league gave up that property and it's owned by the county. One thing that was put in that lease was a step up noise ordinance. And I'm just wondering if this is a direction. First noise ordinance, because they have weddings there. And so weddings love to have bands and bands love to play those good old songs. And so first ordinance, I don't remember exactly, but you got this, maybe a warning. Second, you've got this 500. Third, it escalates. And again, I don't know if it resets every year, but it gets to where the manager of the Taylor Grady House does not want you to, the party to violate. It's enough to make you just not write out a quick check. And again, it goes higher. Is that something that could
just any
go
sort
on
of,
with what you're saying?
yeah, really just any sort of, neighbor relief would be ideal, because I totally see the need, to have the relief out for the owners and stuff. And, I think in concept, it's a good idea for the good properties, but there just needs to be some sort of neighborhood protections if we're gonna grandfather in this, event venue that's in the middle of a neighborhood that's having family reunions and things that should be taking place at real event venues, And, yeah, so I just, I would like to see, as I read it, I didn't see anything in there that really, there's lots of protections for the Airbnb owners, but there's none for the people that are in these neighborhoods that are, the reason we have residential zoning is to keep businesses out of these neighborhoods. And these are businesses. So, when it comes down to it, I kind of think maybe some of this should have never happened in the first place, but like now that we have them, there have to be protections for the neighborhood to stay a neighborhood and not become, have event venues in the middle of the neighborhood. There needs to be some sort of protection from my point of view for that. Otherwise, I'm totally I like Airbnbs. I stay in them, it's great, but I don't, I'm glad I don't have to live next door to the place that regularly has buses pulling up to it, I wouldn't want that. I don't think anybody here would want that. So that's my own issue. Just because I have to see it. I drive by it, my house is a long ways away, but you gotta drive right by it and it's, it's a big party. I'm glad I don't live next to it.
One other comment, I just looked something up and just to get back and forth about this a minute ago about how many, the conforming STRs and I just found on the use table in section 9-10-2, in every commercial district, short-term rentals are a permitted use, right? Which means under short-term rental ordinance, that makes them conforming and thus they're not subject to the sunset, I think. Is that right?
If they have a permit, they're not subject to the sunset. If they don't have a permit, they are still legal non-conforming.
Well, 915-28, the short-term rental section of our ordinance, in subpart B says, the following shall apply to all STRs and the status of an STR as conforming or legal non-conforming. 1, if an STR is permitted outright in a certain zoning district and meets all applicable code standards, it shall be considered a conforming use. So that doesn't say that you need to get a permit.
That's how you're conforming to all code standards. Is the
Oh,
evidence
okay.
of that is the issuance of the permit.
Okay, and what part of that ordinance says they need to, says what permit they need and.
So every commercial use at a minimum, from a zoning standpoint, you have a zoning permit that is issued to you to show that you're operating within the bounds of the code.
Okay, but that's not a discretionary process. We had, I think last month, a application for a special use permit on Oak or something like in Cobham.
Yeah.
Church Street, for an SUP for a short-term rental, special use permit. And you don't need that, right? In a commercially zoned parcel with an STR use, those are permitted outright. And so you just need to get whatever zoning permit or something that's administrative.
I was kind of saying the plans review process earlier. So, and I don't totally understand that because I don't do it, but that's something that planning staff does. So if you have a commercial use, you go to planning staff, they do a plans review. That's, that's part of the process with any commercial use. So if it's a commercial STR, that's how it would, that's how it's conforming is it would go through that plans review.
I got you.
And it doesn't necessarily need a special use permit, but they go to planning staff and just go through the plans review process.
Okay. So those are allowed as of right. A property owner who's running one of those but hasn't yet got a permit can get a permit to do that administratively without any discretionary action by us or the mayor and commission. And so there's a number of short-term rentals in Athens-Clarke County that because they're in commercial zoning districts are not subject to a 2-year or 5-year sunset. It's only ones that are in residential districts that require an SUP or would be subject to sunset.
Almost, okay. So if you don't have the permit, but you're operating, you could be eligible, and it may have been identified to be legally non-conforming because you don't have your permits yet. So you could have, and we do have properties that are zoned in the commercial varieties and in some of the other zones where it's allowed by right, but they don't have the permits yet because they started operating before there was a permit to get.
Yeah.
So they are on the legal non-conforming list to buy them the time to either come forward and get the permit or make a decision to end their run within the legal non-conforming status. Up to them.
Okay, but yeah, it's up to them. So I got you.
And Matt, to help with that, because I can understand a little bit of confusion. One thing that we did in this update to 9/15/28, if you look at C1 in the proposed ordinance, it says if an STR is permitted outright in a certain zoning district and meets all applicable code standards, including securing all required permits and approvals, it shall be considered a conforming use. And so to kind of address that point, staff had kind of updated that a little bit to help make it clearer.
Okay. And in residential zones, they can get an SUP. So then they'd be under C2. If it's approved as a special use, it's a conforming use if all necessary permits have been issued.
So not in single family,
Okay.
only in the RM, only in the mixed density.
Okay. And so in an RS zone, it's not approvable as a special use. Those are grandfathered in for the
You get a home
24.
occupation
Okay.
to operate.
Okay.
And be legal and come off the legal non-conforming list.
Okay.
But you cannot have a commercial short-term rental. And the fundamental difference there between the two is commercial short-term rental doesn't require that the operator of the short-term rental be on site.
Right.
Whereas the home occupation version does require the operator of the short-term rental to live at that address. So it pulls those apart.
Gotcha. So commercial is a conforming use if you get the permits. In RM zones, it be made a conforming use by getting the special use permit. In RS zones, those are going to be timed out by the sunset clause and there's no special use permit
Or get your home occupation.
option or get your home occupation. Just for, in an RS zone where you have like there's a duplex or a triplex that was built before zoning. If it's owner occupied, but they have a couple of rental units, does that count as the home occupation? Short-term rent, if I live in half a duplex and rent out the other half as a short-term rental, is that a home occupation?
You're zoned RS?
Yeah, it's a legal non-conforming duplex in an RS.
It's all in one property. That's how I thought I read
So these are the things.
it. Like if it's an AUV.
Yeah, it's a one tax parcel with.
Yeah, which is why the parcel definition probably matters
Single
too.
tax parcel allows you one.
Yep.
One short-term rental. If you have a duplex that's legal non-conforming, sitting on that single-family zone parcel, one half is used as a short-term rental, you're okay. Because you have one on that tax parcel.
Okay.
Now, not to make this weird, but with this text amendment, if that owner of that property should go condo with their duplex, each side of the duplex is now a tax parcel. So each side can be a short-term rental, home occupation. Because each parcel now is eligible for one.
Okay. Okay.
So they could each like rent out a bed.
Okay. Or I mean, I could rent out my whole house as a home occupation Airbnb and I just would, go to Atlanta on game days and rent my house to.
Still your residence.
Yeah. Okay.
Yeah, as long as it's the primary residence.
Yeah. So I had Jen and then Kristen.
I have a question about conveyance, to Mr. Silva's point. So if you have either the special use permit or you're conforming, can you convey that? So if you sell the property, can the next person operate as a short-term rental without having to go through the process again?
So the conveyance statement might have been related to the legal non-conforming. That's one of the things.
So if you sell and you're on the sunset list,
In the event of sale, the legal non-conforming use shall be null and void. So if you've made it conforming, that can be transferred with the property.
Well, and how does that work as a practical matter? If somebody's seeking to do a conforming STR on the property moves?
So we're really digging deep into operations here, but if somebody gets a permit legally and makes their property a short-term rental, whether commercial, home occupation, doesn't matter. As long as they only come to see us once, annually, they will go to the finance department and they will pay their taxes and handle their occupational tax certificate. Okay, that's an annual thing. If somebody were to sell that property, the permit for the short-term rental can transfer, but if it is abandoned, if it's not used for 12 months or more, then they've lost that and somebody would have to come back and make reapplication to do it. And the way we would track that is the activity of having gotten your OTC each year and paid your taxes each year. If a cycle goes by where that hasn't occurred, the assumption is that you've abandoned the use and you have to start over again.
Let me just make a quick proposal, because I'm sure we could go on for another hour, but I think we've been going about 90 minutes on this item. We have a very long agenda. So unless it is the sense of the commission that we will be ready to vote quite soon on this, there's a lot of interesting questions we could discuss. It may be that we ought to consider tabling this to next month, so that we can dig in deeper on these examples, consider it further, and, you know, and come back to it.
I'd like to talk about it more.
Hey,
I'd be in favor of that.
a good bit of the discussion tonight, which is healthy, is really talking about the ordinance we already have. You know, and we can certainly do that as an educational item in a work session format. Happy to do that. Because it's got a lot of stickiness to it, and it does lead to if-then questions. And believe me, every if-then that you've thought of, we've got phone calls that take it into new directions. But really what's on the table tonight are these three headings of change. So I think, if I may, I think if you're comfortable with these three headings and having discussion about them tonight and finding some peace here, then that may offer the opportunity to take some action. If you're not comfortable with these three headings, then that's a reason to maybe discuss further.
Are
But
we voting on them individually or as a?
no, it's one set of text.
Okay.
Can I ask another question about that same thing? Oh, I'm sorry, you go ahead.
Well, I just wanted to, I think I appreciate what you're saying, Bruce, but I feel like some of what we're talking about is kind of wrapped into like, how many properties are we talking about? I feel like, I kind of want to get a sense of like, are we talking about 300 residences in a single family neighborhood? Are we talking about 1,000? Like, because to the point of taking up property that could be a full-term rental, like that's a legit question. And I kind of want to get a sense of the scale of what we're talking about. And also to the ordinance in front of us, I appreciate what Mike was saying about the neighborhood return, because I don't know if the 5-year sunset clause is really addressing that portion of it. And this whole time we've been talking, I'm thinking about what is the problem we're trying to solve? And it's the housing crisis manifested through short-term rentals, which I feel like I need to have a better number to adequately gauge what that crisis is. And also how this is manifesting in neighborhoods where we have these massive rentals that are causing the problems. Because my guess is it's a really small percentage of short-term rentals overall. That's just my guess. I could be completely wrong. And then is what we have here going to solve that problem? Because I feel like we were solving the problem of any sort of potential lawsuit around a sunset clause, but is that really creating more problems than actually solving the problem? So with that, I would like to propose a table.
Well, can I address, I might be able to give you a number, maybe some other numbers will come out of this discussion.
Right.
The legal non-conforming list has 711 properties on it right now. Okay, that's down by 100 from where we started when it was first developed. So we've already seen attrition of about 1/8 on that legal non-conforming list.
Speaking that some of them have gotten permits and they
Got
are now.
permits. Some people asked to be removed from the list. They had no interest in operating. So that number has gone down already, and the legal non-conforming list can't get bigger. It can't grow. It's set. It's done.
Do you have numbers by zoning classification, like commercial RM and RS within that?
We do. We do. Not at my fingertips, but
My point, like with the sunset clause, like, so we're talking about less than 800 properties total that could potentially be affected by the sunset clause. I know it won't be all of them, but like. That's
711 will be impacted by the decision on the extension of the sunset clause.
if they do not get a permit, if they do nothing.
That's right. So 711 would stand to benefit, not just from the sunset clause, but also from the relief valve.
Right. But
I
like,
think it may be that 400 of those are in RM or commercial zones, or 100 or 200 or whatever.
Right.
So it'd be useful, I think it'd be useful for us to have very detailed data on that so that we know exactly how many are going to be affected by the sunset clause.
Do we have any data on like how big they are?
Let me,
Because, like my concern of only, oh, sorry. Go ahead.
I was just going to say, if none of them choose to act, it's 711.
Right.
I mean, there's the answer.
Right.
So, it's good.
But that's their opting out of a procedure that we've offered them.
Correct.
So we don't need to worry about them sunsetting. If you're in a commercial zone and you don't seek permits, that's on you, right? So
Under any scenario that you're contemplating, the number goes down. It can't go up.
Okay.
It can only go down.
Of the 711, some of those are in RM.
Some are almost in.
But those can apply. Like that number can go up, correct?
No, if they make application for a permit, the number goes down because they're now legal and conforming.
yeah, they're conforming, they move off the non.
Yeah, they're off that number, but they're still doing this, which I think we're trying to.
Somebody in
figure
like
out
RS could.
How many are out there doing
Right,
it?
but- What I would offer is the sunset clause is for a period of time, right? A time certain where there is a percentage of the 711 that may not ever be able to comply with code. And that at the end of the sunset clause, and let's say they use the relief valve and they get some additional time. At the end of that, if the rules don't change, they'll have to cease operating. Now, as far as what that number is, it would be very difficult for staff to give you a firm number on what that is going to be because it's all based on choice, right? But we could look at zones, we could look at things that could change. We have property owners that have purchased these and they have no desire to operate the short-term rental any more than they want to have a beauty salon in their garage or other things that they're allowed to do. So on the issue of the number, I just want to make it real clear what we're talking about. So legal non-conforming list is the only group that's impacted by the sunset provision and by the relief valve. That's it. So it's not the 1,000.
711 properties.
711. So if that's helpful.
Do all of them have the opportunity to become legal conforming from that list? You're saying there is a number that may not ever be able to.
There's a percentage in there that there's no pathway to becoming legal and conforming.
Right.
And
that's the number.
The code is written, right?
Okay. I mean, personally, I would love to see exact numbers about how many are conforming. And then of the 711 legal non-conforming, how many are in commercial, how many are in RM, how many are in RS zones, just to give us the scope of what is before us. I think, to me, that would be helpful in deciding. The second thing that comes out of what Mike said that might be a useful pursuit if we table this for a month would be, surely there is some additional text amendment that could be made to identify and remove legal non-conforming status early for bad apples. You know, whether it's a certain number of code enforcement violations or exceeding occupancy limits or what have you, and so that might be a beneficial pursuit in the next month to just kind of add something like that to this package. I think that would
It would help me out for sure.
It would help Mike out. It would help me out. It would probably help some of the mayor and commission out, and some members of the public would be interested to see something like that.
If I may kind of put some words around that, what you're suggesting is the revocation of a permit for a use. You're asking for the permit to function in that use to be taken back.
Or like
Based on performance, based on some measurable,
Yeah.
whatever. But I can tell you in our code right now, we have no provision. We do code enforcement, but we have no provision that says we're going to take back your zoning permit. You just, you go through the judicial process, and Austin, I guess, is probably the best person to speak to this. There is no revocation of a zoning permit.
That's correct. I mean, if someone violates, if someone's approved for a particular use, it's discovered that they're violating the terms of that permit or their use, they're subject to being prosecuted in municipal court. Actual zoning permit.
So that maybe ask is kind of an order of magnitude that's a little bit bigger than it may seem. Because it does open the door for an approach that we don't use for any use permitting at all.
I was gonna say, maybe it's like a 2-year sunset, and if you're good, you get a 5-year sunset. And then you're not taking something away, you're granting something. Because because I don't want to be against the 5-year and the relief valve for everyone, just for the trouble properties. So like maybe it's like, okay, if you're one of these bad apples, you stick to the 2 years. If you're a good apple and you have no code violations, then you, at the end of that 2 years, you're automatically bumped to 5 years. It's like you get your good, it's like a reward for being a good apple. And then, I don't know, I would be in favor of that kind of thing, because like I said, I have nothing against probably out of those 700, 650 are probably good apples, you know? But I want to see some sort of relief for the people that live next door to these bad apples. And I think that that's something that, you know, maybe the good apples would probably be on board of too, because what they want, I don't know, something to think about.
Yeah, thank you, Mike. I see, Carrie.
Yeah, I would just be curious. We're talking about all these bad apples. Seems like they're just on every block perhaps. But I'd be curious to know the number of issues that we've had, like, is there some quantifiable number of operators of Airbnbs and short-term rentals in town that have had code violations against them or that have had multiple complaints? Do we have a number like that?
So because the ordinance is only a year old and because we've been in a grace period of identifying and education and trying to help people get on the legal non-conforming list if they're eligible, we have not, our code enforcement has not been specific to the short-term rental standards. What we've been enforcing are the things we've always enforced, which would be the operational things of living in a neighborhood that apply not just to short-term rentals, but they apply to all of us. The parking violations, the garbage cans, the noise, the light, those things are all offenses that can have warnings and citations written today, regardless of whether you're a short-term rental or not. So if we run the data, first of all, we don't have a very good sample size right now because we're still developing the list, but there's a list and there are properties. Issuance of warnings and citations for those properties that are known to be short-term rentals, because they've told us they're short-term rentals, it's not going to be a very large number. But what we do have is all kinds of data for parking violations of things countywide. So that's where it starts to skew, is that's something we do for everybody all the time now anyway.
Right.
So you're asking for performance data, which is fair. You just don't have a sample size to make policy decisions on. But if we got up and running, we will have those.
And Bruce, just one other kind of point of clarification on that. When you talk about a warning or a citation, that's not a plea in municipal court necessarily either. That's just a warning or a citation. So those are two separate and distinct things. You know, the citation is what gets you municipal court. There's action that occurs in municipal court afterward.
I think that's my challenge. I'm trying to understand what modifying the short-term rental requirements does. Like, if we already have things that they should be complying with, but there's no enforcement in place, then if we make a change, does the enforcement also change, or like, how does that work?
And I don't want to make it sound like there's no enforcement. There is enforcement. But we've been going through a process of developing this legal non-conforming list where we've had to work with people. So we can't go shut somebody down when we're trying to help educate about what your options are. So that's where we've been. So I may have said that wrong, but what's proposed here, the handful of things that we've got here that are different and new do help with enforcement. It will help bring clarity. The notification process becomes an enforceable thing. And it's a more achievable notification process. So that's good. It's good on both sides. The sunset period obviously tells us what we can do with enforcement for those folks that are identified as legal and non-conforming. It's a period of time where we will not be doing an enforcement as a short-term rental, but we would still be doing enforcement about the parking or the noise or the light or the trash. Those would happen regardless. They don't get to do whatever they want all the time, anytime, right? It's only as it relates to short-term rental operation itself. They don't have to come get a permit for this period of time to be legal and conforming. That's all it buys them.
Okay, so we have a motion that was made, we don't have a second yet, but I need to bring us back to that. Kristen made a motion to table this until next month. Mike has just seconded it. And we can have discussion of that motion as necessary, but I'll just say that in the interim, we'd like to see a detailed breakdown of how many conforming STRs there are now and how many legal non-conforming of the 711 are in different zoning districts, that enable them to become conforming, and how many are in a zoning district where there's no path to conforming, which would be sunsetted at some point in time under this proposal and under the current ordinance, just to give us a sense of the scope of what we're dealing with here. So at least we want that, right? It's your motion. And is it also part of your motion to ask staff, the attorney's office to ponder on the question whether there is any additional way to address bad apples?
I do, although I'm listening to this discussion and I feel like what you were mentioning, Bruce, like, we don't issue business permits. We're dealing with land use. So the issue of like whether or not you can have a short-term rental in any of these zoning areas, sure. But like there's other things at play. And so I wonder if what we're trying to solve is more of like a business license issue that we do not have any control over, you know?
Or code enforcement.
Yeah, it's code enforcement. I mean, I'm thinking of like how you would lose your liquor license, you know, like there is something in place for that, for example.
Yeah.
So, or like a food and beverage permit, like there's licensing things, so it's more of that issue, which is not a land use issue. So that's kind of what's bubbling out of my head right now.
So I would just like some sort of, you know, increased neighbor protections or some sort of way to deal with the bad apples. Ideas? I don't know.
Okay.
Yeah.
Discussion,
yeah, Alan.
Just a couple of quick things. Still working the tabling thing out, but particularly for new members, this original text amendment was actually sent to the planning department from the mayor and commission, or the mayor. Normally, as I understood, and this is what was said back then, a lot of these text amendments start with planning. They see a situation, they start saying, hey, if we change the text in this, then we can improve. This came from elected officials to the planning department to solve. One of the citizens, one of the neighbors that brought this to so much crisis was somebody that lived next to a house that was she saw it was on Airbnb or something, and it was gonna have 18 occupants, something like that. So this person was complaining about that. She admitted here that it had not been rented out yet. It was still in the construction, and every single complaint she had was construction complaint. It was not anything to do with short-term rental. It was, she understood it was going to be a short-term rental. So that got everybody talking. So, and as somebody in real estate, and I do not deal with short-term rental investments, that is not my thing. So that's why I'm here or able to stay in the discussion. It's not the crisis is to the neighbor, but not to Athens. Athens is not going through the crisis. We can argue that, and I don't want to get too far off of the tabling, I promise you, for the tabling. But so what I want to say is what I'm having an issue with the tabling is the sunset, when that was added at the end of our discussion originally, that was not part of it. And one of our people on the commission said 2-year sunset. And I voted against all of it, which is, you know, that's old news. But I would only vote for this if we got rid of the sunset. It's not making sense. This stuff right here is going to get complicated, and just let those who have done it do it and continue on, and then don't do more RS. But I would be very much against the sunset. So I'm not sure right this very second if I'm going to vote for or against the tabling because of that, because I might rather it come back and we vote against the sunset, move this on down, because the parcel thing makes sense. That kicked us in the butt. We didn't see that coming. And no, I mean, it wasn't, it was just who knew? And there's a lot of who knew in this, and I don't think we're over with the who knew. And lastly, the notification thing I could probably live with. I just think it's good neighbor to do. But so anyway, that's how it pertains to tabling here, is I am still not sure if I'd rather it not be tabled, vote the sunset out and move forward.
Are we ready for a vote on the motion? All right, should we do roll call?
Motion to table. Morales,
Yes.
Please,
Yes.
McLaughlin,
Yes.
Pass.
Yes.
Sams,
No.
Sanders,
Yes.
Lord. Yes. Motion passes 6-1.
Can we do one more item and? We're gonna do one more item before we take an intermission.
Okay. See if I can wait that long.
The next item on our agenda is, that's really. Under old business, it's item 1, and that is 110 West Hancock Avenue, and we will begin with the staff report.
All right, thank you very much. Max, tell me when we're. Good? It's, okay. Okay. Lawrence Line is. Avant-garde, always. All right, 110 West Hancock Avenue. This is a special use permit request. This came before you at the previous meeting at which. Oh, this is the Hancock.
I need, Mr. Chair.
I'm sorry.
Yeah, I'm sorry. Yeah, I was just saying, I need to recuse myself on this one. I didn't know we were jumping to this one next. My wife works for the church and that's a financial interest.
Right. Thank you, Alex. So.
All right, 110 West Hancock, special use permit request for the development of a surface parking lot in the commercial downtown zone. This item came before you at your previous meeting. It was held to allow for further development of the application. The specifics of the request involve removal of the existing office building that's on site and replace that with 14 new parking spaces. It would have access into this parking lot from Lumpkin Street. There would be a landscape buffer provided. No waivers are requested. And this is included, as was mentioned earlier, as part of a mediation settlement agreement with unified government. Aerial view of the location shows 110 West Hancock there, kind of in the black and red hatch outline. The white roof is the older portion of the building, built sometime between 1918 and 1926. The gray part of the roof to the north was built in steps between 1950 and 1960 and is, the front is referred to as the Say Building. The collective is referred to the Say Building, but that northern portion is actually referred to as the Metropolitan Building at the time of its construction. And the keystone is up in the upper part of the building that says so. The parcel is not just the building footprint. It includes 27 angled parking spaces to the west, and then a very informal concrete area to the north that holds approximately, I think, 6 parking spaces. It's often used for the Chick-fil-A delivery vehicles operating out of the downtown Chick-fil-A. The future land use map would not change with this request. It is noted as downtown. The zoning map also would not change other than the designation of the special use. Should it be approved, it would remain. What has changed in this particular image is, as of Tuesday night, the hatching that's shown there as being part of the local historic district for West Downtown. That designation has been removed by the Mayor and Commission on Tuesday evening, so that hatched mark would no longer be shown, is no longer shown on the subject property. Some photographs. This is looking from West Hancock directly at the front, the older portion of the Say Building. This is looking from Doherty Street to the rear. And then kind of looking up Lumpkin to where you can see that side view, and you can kind of tell from the parapet how the building has evolved over time. This is right across from the stop. Submitted site plan that would become binding upon approval for the special use is what you see here. You can see the 14 parking spaces, access off of Lumpkin, which is to the bottom of the screen. here, two-way access. The area in green would be landscaped and you would see the street trees installed as shown. There would be some modification of the sidewalk along Lumpkin. There would also be some dedication of right-of-way at these corners, which is standard procedure. Analysis of the request as follows. What's being asked for is incompatible with the 2023 comprehensive plan. Doesn't encourage preservation and adaptive reuse of the existing structure. Does not decrease the number of vehicles downtown. Park, and that's not parking, but green space, park space. Does not follow policies for housing, land use, transportation, and infrastructure, economic development, or design. It's incompatible with future land use map expectations for the downtown designation. It's also incompatible with the Doherty Street downtown design area expectations as expressed in the zoning code. That concludes the staff report. We're available for any questions. With that.
Thank you, Bruce. At this time, we will hear from the applicant. Is there anyone here from the applicant? Okay, we will move on to public comment. The applicant has apparently chosen not to speak in support of this application. Is there any member of the public here wishing to speak on this application?
Hi again, everyone. My name is Denise Santa and I live at 125 South Arcadia Drive, and I serve as the engagement coordinator for Historic Athens. Tonight, I'm here again to respectfully urge my special use permit application to replace the Say building with surface parking. While the building is no longer in the West Downtown Historic District, the values that have guided its protection for years have not changed. The Say building is still listed in the National Register of Historic Places. It is still a 23,000 square foot structure with cultural, economic, and architectural significance. And it is still a site with tremendous potential for adaptive reuse, right in the heart of downtown Athens. As a planning body, your charge is to consider how projects contribute to the built environment, the local economy, and the long-term health of our community, not just whether they meet minimum standards. The project before you would remove a sizable building in our downtown area and replace it with a net gain of 8 parking spaces. No matter how you feel about the Say building or the recent legal proceedings, this proposal does not align with our community's planning goals or the downtown comprehensive plans for the past 25 years. It reduces downtown density, removes taxable square footage from our city's core, and introduces surface parking, all of which run counter to the direction Athens has consistently moved in for the last 2 decades. To be clear, we are not opposed to parking or to thoughtful development. The proposal is neither. It offers no long-term public benefit that we know of, no site plan for the future use that they have repeatedly said is something other than parking, and no timeline for what comes next. Despite the last several years of public discussion on this site, no details on that future intended use other than parking has been shared. You're being asked to approve demolition without knowing what, if anything, will replace what we lose. What this proposal does guarantee is the permanent loss of a downtown building that could still serve as housing, small business space, nonprofit office, or even a mission-aligned program of the church itself. This commission has shown vision in prioritizing density, walkability, and long-term planning in downtown. This project goes in the opposite direction of what our community wants and needs. It doesn't ask for your partnership, it asks for your permission to tear something down before a plan is in place. We urge you to reject this special use permit and help set a better precedent, one that supports smart growth, sustainability, and more thoughtful vision downtown Athens. Thank you.
Thank you, Ms. Lunta. Is there any other member of the public here wishing to speak on this application? All right, seeing none, I'll bring back my mail. Kristen.
Yeah, so I think it's interesting. I've been on the commission for 7 years and I don't think I've ever seen anybody not show up to support their project. So I just wanted to stick a pin in that, but that's just kind of interesting to me. Yeah, it's too bad the applicant is not here because I wanted to ask them about the cost of tearing down the building and the cost to produce all of these plans and the cost to have all of the evaluations done for the building and the cost to redevelop it into a parking lot. And just all of those costs versus having a building where I actually, as a former small business owner, would love to have, we do not have enough office space for small businesses. So it would be a tremendous opportunity to have a space in that building. So with all that said, and I also, Bruce, could you go back to that very first slide real quick? I just wanted to also, just a quick question. There was the last bullet point, included as part of a, sorry, second slide, included as part of a mediation settlement agreement. And I guess I just wanted to ask, as far as the mediation settlement agreement, like if this goes before the mayor and commission, that mediation does not say one way or the other that mayor and commission has to vote on this a certain way, just simply that it is not a precedent setting decision one way or the other. That was what the mediation said. And I guess it's a lawyer question, not to put Bruce on the spot.
Yeah, that's what, that last provision that I read to you all earlier on, that's it.
Right, I just wanted to like make sure that it's, yeah, like, so just to reiterate, the mediation did not set that there had to be a decision one way or the other on this, on a planning decision, so. Yes, okay. All right, well, so with that, I wanted to recommend denial.
Is that a motion?
Yes, I want to make a motion to recommend denial.
Okay, very good. And motion by Kristen and second by Jennifer. Discussion of the motion. I'll just.
Yeah, no, I agree. I don't think it meets the, criteria. So, yeah.
Yeah, and just to.
That doesn't meet the criteria for special use. I don't think a parking lot's a good downtown use and, I think a good historic building has lots of other values. So, yeah. I agree.
Thanks, Mike. Yeah, just a couple of comments. I think it's clear from the that there's not a need for more parking. The church, admitted at the last, the representative of the applicant admitted at our previous meeting where this was on the agenda 2 months ago that they don't need more parking for their church services. And I was hoping to ask them, had they appeared today, what the purpose of this is if they don't need more parking. So I'm sorry that we don't have the opportunity to have a discussion with the applicant, but it doesn't seem to me that there's any public benefit to this application. And I think it clearly does not meet the standards in our code for a special use permit. So if those standards mean anything, and if we're going to faithfully apply the code of ordinances of Athens-Clarke County, I think we can't possibly make the findings required to support granting a special use permit here. So I also think need to recommend denial. And I guess the last thing I'll say is that in downtown land use, it's pretty universally understood that a surface parking lot is the least appropriate use in a downtown area. And which is why our comprehensive plan does not permit them. And so we would not only have to violate the ordinances to approve this, we would have to depart from all of our planning documents, which the state requires us to adopt on a regular basis, and which we adopt and say that we're going to follow. So I don't see how anyone could find that this is appropriate in light of our planning documents. Any other discussion of the motion?
I just want to say I agree wholeheartedly.
Say,
Yes.
seems pretty cut and dry to me. Yeah.
I brought my son and Bruce as I sat down. I grabbed my 2018 notes. Because Kristen and I were in this room on November 1st, 2018, when this came up. And my notes are the same. They're the same then as they are today. This is not an appropriate use. The request has never, it's always felt disingenuous to me. I've never believed that the parking lot was a true goal. That part doesn't matter. It's just a totally inappropriate use of downtown land.
I guess I'll just add one more thing. I was looking at our bylaws and it mentions that the burden is on the applicant to demonstrate by clear and convincing evidence that all criteria for issuance of the requested action has been satisfied. And so, but the applicant by not appearing, I think, plainly has not met that burden. Add that to you. Yeah. All right, should we do a roll call?
I guess the only thing I would maybe add to that, just to be very clear, I actually don't care that they're not here. There's nothing that they could say that would make me think a surface parking lot downtown would be okay. So I just don't want to get kind of caught up in the procedure of them not being here and have that somehow be used in a way that doesn't serve our purposes. So it's very clear to me.
Parking lot is the worst thing. All the ideas.
It always has been.
Yeah.
8 spots.
Yeah, 8 spots.
8 net spots.
Okay, any further discussion of the motion? Okay, Stephen, do you want to call the roll?
Motion to deny, Morales.
So a vote of yes is the support of a denial.
Yes is to vote to deny it.
Yes, so yes.
Please,
Yes.
Beresford,
Yes.
Laughlin,
Yes.
Pass,
Yes.
Sanders,
Yes.
Moore,
Yes.
motion passes unanimously.
Now would be a good time to, 5-minute intervention.
Thank you. Thanks.
Right, call the meeting back to order. Next item is under the old business section of our agenda, item 2, 4500 and 4530 Atlanta Highway and 125 Road. We'll begin with the staff.
Good evening, everyone. Benefit of the attendees, my name is Stephen Jaques. I'm on staff here to present the staff report for project here at 4500, 4530 Atlanta Highway, Bedford Road as well, also known as Winslow Park. You have seen this twice before. It's back for a revised master version, so it is up for a vote tonight. The request is to amend a CG RM2 and RS5 PD, so commercial general, mixed density residential, and single family residential land development. For the purpose of building 925 residential units. Those are split up into 396 single family detached units, 216 single family attached units, townhouses, and 313 multifamily units. The plan reconfigures the lot, block, and street layout of the existing binding plan to add 125 units to the existing 800 unit plan. So this is already entitled for 800 units, and the request is to add an additional 125 through a redesign of the. However, it does not propose to construct or alter the binding plan for the commercial at the Atlanta Highway frontage. It also replaces the architectural pattern book with the developer's stock. There are 6 waivers. Staff supports 1, opposes 2, and has conditionally supported 3. All of those are laid out in your staff report for you to reference and see our opinion as well as the staff's, the applicant's purpose. But the Winslow Park plan development that was begun, approved, entitled in 2004, amended in 2005, amended in 2007, and the current plan dates to the latest amendment from 2015. This is an aerial of the site. At the top, you have the CSX rail line. Towards the bottom, you have Atlanta Highway. It ends into Highway 78, turns onto Monroe Highway here, on the bottom left. You have Coggins Industrial Park to the right. You have some residential to the left, including a project that you all approved last year at 5100 Atlanta Highway, which was a number of townhomes. You can see the site itself is heavily wooded, with the exception of a lake and creek with some riparian areas that runs through here. And you can also see where previous development has cut roads, what were to be roads, where the project stopped. Future land use is split between mixed density residential on the majority of the property, and then commercial general up here at the front where it touches Atlanta Highway. That was where the commercial portion of this PD is slated to go. Zoning is also similarly split. Portion that would be single family is zoned RS5. The portion that would be multifamily, the townhouses, that's going to be your RM2, this brown area. It's going to expand slightly to cover this section. And then the portion up at the front is commercial general. That's not changing. This gives you an idea of some of the environmental areas on the site. You have the water that I referenced covered here, this light area and this green. And this is the current version of the site plan that's being proposed. I'll go into more detail. I'll blow it up in just a minute, but generally speaking, you've got single family here at the top. You've got townhouses on the bottom left. You've got the Aceda duplex units right here. And then you have the low-rise multifamily at the bottom right. You have a roadway connection to Atlanta Highway here, a secondary one here, and potentially a third one to Whitetail Way over here. So you zoom in on the map. This is top left. You'll notice a dark area right here, that is the set aside for a public sewer connection that would enable that other project that you saw at 5100 Atlanta Highway to move forward with their project by giving them sewer access. There's a condition to that effect that's in the staff report, if you want more details. This is the top right portion. This area was slated on previous versions of this plan to have homes. Those have been taken off. It simplifies some of the engineering, keeps them out of some environmental areas. This area right here is where the waterway, the creek flows through to the lake. There's a dam right here. This dam would be repaired and a road would be placed on top of it. These are all single family right here. Townhouses on the bottom left. Duplexes here, top right, and then low-rise multifamily on the bottom right. Some of the sample of elevations. You have a large packet of elevations available to you in your packet. Single-family detached. This is not exhaustive, going to be an exhaustive list. Refer to your packet if you want to see every single one that's being proposed. Single-family detached. More single-family detached, single-family attached townhouses. This is what they would look like when they are stuck together. This is the low-rise multifamily. And these are the duplex units. Our staff recommendation, our analysis really has not changed much since we first saw this project. We deem it to be incompatible with the 2023 comprehensive plan, most notably in its limited housing variety, no construction of the commercial node to go with this project, minimal connectivity, limited green space in some ways. It is compatible with the future land use map and the zoning map because those aren't being asked to change. Zoning map's being slightly modified, but just the boundaries, not the actual zones. However, incompatible with future land use character and also the zoning ordinance, there are a number of corrective actions that they will need to take that are specified in your report. Some of them related to the architecture, many of which can be handled in plans review, but those are all spelled out for you. There are things that are going to have to change to make this approval. As far as the waivers, staff supports 1, opposes 2, conditionally supports 3, and those are all laid out in the staff report. The larger issue is that staff has observed on multiple projects around town, including this one, a design drift. You start the original concept based on a lot of new urbanist design principles, projects like Whitehall Village, Somerville, most recently Oak Grove. That first phase gets built. It's built according to those design principles. And then subsequent phases drift and drift and drift further apart from that original design intent. That's what we're concerned about seeing here. Birkdale Village, a new urbanist designed project outside Charlotte that was the inspiration for this project, as stated in 2004. And this proposal would depart from that spirit. Specifically, reducing the housing variety and the distribution, getting 4 or 5, depending on how you classify the smaller. There's 2 types of single family. One's a smaller version, one's a full size. So maybe you can consider that an extra type, maybe not. We would expect more than 4 types of housing on 200 acres. And we would expect that to be distributed, mixed together across the whole site and not in the pod as currently proposed. We also don't have civic spaces here. We would expect more focal civic or central green space as proposed previously, rather than the limited strips that are being proposed in between the houses. This has been mixed use from the get-go, so not building the neighborhood commercial node to go with the project prevents it from meeting the spirit of the project, as well as serving as a neighborhood center as labeled on our growth concept map that is the first version of the update to our future land use that's currently going on. So the applicant has bought into a mixed use project, and it should not be a surprise that the expectation is that it would be mixed use. Even if that land has been sold to other owners, it is all still part of the same PD. So that's not necessarily micromanaging the market, it's fulfilling a community expectation. Substituting alleys for streets, staff has objected to this, voiced concerns about it on previous versions of this plan. Substituting alleys for streets may be appropriate on very constrained sites, very small sites, applied in a small scale. But it's not necessarily appropriate to apply at the large scale as proposed here. Public streets fulfill a variety of connectivity purposes. They allow residents to access whatever they need to access, to meet their neighbors, to allow visitors. So we just don't feel like that's a tool in the toolbox that should be appropriately applied here. Also has flat architecture. A lot of attention in previous versions was paid to elevating the architecture and building on some of the Southern home building traditions, and this is stepping away from that. So what we're really seeing here is some density without the other design principles that make density into a good place to live. Mark, is it selected? So close a little bit by making some general points that aren't just applicable to this project, but to others as well. As a staff, we're charged with stewarding the community's interests, its well-being, not just to address today's challenges and conditions, but to the future as well. We've listed these factors that it's not just about getting affordable housing, but you also have to think about the fiscal sustainability of infrastructure, the human social connections that built environment is going to enable, economic opportunity, environmental sustainability, the resiliency of the buildings, their adaptability, their beauty that inspires people to care and maintain them. As a staff, we don't see these elements as a zero-sum contest. They're all necessary. They all have to be blended together to create a successful community. And in fact, if you go around the country to some of the other new urbanist projects that were designed with those principles, they've created more value in the long term for all parties. It just didn't necessarily deliver the quick financial returns. So the real question here, well, current and previous plans seem to have met these needs, and the proposal deviates from that. The real question then is, does the ask for 125 additional units justify the waivers and the deviation from the existing plan's design principles, layout, and code? And in staff's opinion, more density is fine, but there isn't enough benefit here to justify those deviations and waivers. So we are recommending denial. However, should you choose to recommend approval, we do have 6 conditions that we would advise you to include. They are laid out here. They are laid out in your staff report, conditions 1 through 3 here, and then conditions 4 through 6. That concludes the staff report.
Thank you, Stephen. At this time, we will hear from the
Good evening. My name is Buck Bacon. I'm with W&A Engineering. I represent the applicant. Do we have the PowerPoint?
Yeah, I'm trying to get up for you. Just come. Winner, green button, as soon as. I'm gonna have to scroll through it for you though, Buck.
Okay. Understood. Okay. So I want to start by expressing my appreciation for our planning staff and their engagement in this process. We really have a great group of folks and professionals in our planning department. I also think it's okay for this commission to weigh staff's review against the broader background of the community needs. And I think that's what we're here to discuss and do. The theme of staff's report is that the proposed PD is a departure from new urbanist principles that were embodied by the original PD. Rather, we think that this project does retain those principles. So the project is walkable. There is connectivity, though that connectivity is limited by the railroad tracks and other environmental areas. This is the residential component of the overall mixed use in the area in the PD. It has a mix of housing types, and we believe that the architecture is of good quality. It has a traditional neighborhood structure. It does increase the density. It's designed with expansion to our transit system in mind. The infrastructure is sustainable and resilient, and we do think that this enhances quality of life and provides aesthetic beauty. You roll again, Mark. So this exhibit represents the new urbanism principles on the top with a cross section of the Winslow Park. So we look at the far right, we have the commercial that's not part of this development. And then as we go from right to left, we can see entering into more of that natural zone. Next slide. So I don't think we've done a great job of really highlighting some of the green space that's involved in this project. This project is 200 acres. Of that 200 acres, we're conserving 42 acres of existing tree canopy that will be used for passive recreation. We're restoring the existing lake. We're planting another 53 acres of new tree canopy. And in addition to the passive recreational opportunities, this project creates another 10 acres of open green space. Next slide. So conditions 1 through 3, we agree, no sweat. Next. Conditions 4 and 5, we disagree. Condition 4 involves a waiver to the on-street parking minimums. It's simply infeasible for us to achieve the network of green spaces and alleys without a reduction in on-street parking. And condition number 5, this involves constructing the commercial portion of the overarching PD. Our client does not own these commercial tracts. It's outside the scope of this proposal, and our client does not have control over the commercial tracts being developed. The commercial opportunities are still available. They are not being vacated as part of this proposal. Next slide. There's a question about waiver 1, so I wanted to make sure we provided you guys with the adjusted development acreage. Next slide. So waiver 2, staff is recommending denial. This waiver is necessary to orient the building towards the proposed green space and the courtyards. And we think that the community's social interactions are intended to occur in these courtyards and not in the streets or the alleys. And fire and emergency have approved this design. Waivers 3 and 4, staff support. Waiver 5, this again is related to waiver 2 and 6. It's necessary to orient the buildings towards the green space. And we still believe that the community's social interactions are going to occur in those green courtyards. And then waiver 6, again, necessary to orient the buildings towards the green space. Next slide. So in closing, this project creates 925 new residential units across 4 different housing types. There is adequate infrastructure to serve this increase in density. Some of these residents will be priced as low as $250,000, and we don't anticipate any units being priced much over $400,000. No project is perfect, but we also shouldn't allow the perfect to become the enemy of the good. The original Water's Edge project has made no progress in the last 20 years. This community is facing a shortage in moderate and middle income housing, and we have an opportunity to make a difference. We're asking that you approve this project as proposed, the requested waivers, and reject conditions 4 and 5. Thank you.
Mr. Bacon? At this time, we'll open it up to public comment. Is there any member of the public here wishing to speak in support of this? Is there any member of the public here wishing to speak in opposition? Seeing none, we'll bring it back behind the rail. Who wants to start us off?
So as I was going through the pattern book, I guess, what do you call it? The designs, I wrote down the three words that came to mind: garages, driveways, and windowless wall. And then as I got looking more toward like the whole layout, I really don't like how we have this portion for this and this portion for this and this portion for this. I just, I see so much value in creating neighborhoods that have mixes of housing within the entire space. Like portioning off this portion for apartments does not benefit anybody. I would ask, Buck, I don't know if it's a fair question for you, but like, I just want to know, like, why not go with the original? Like, why can't the developer just go with the original PD?
Yeah, so, this, there's no mystery, right? The developer is D.L. Horton. They have a specific product, and this represents the products that they build.
So then what happens to the commercial portion of this?
Yeah, so D.L. Horton does not have control over the commercial portion of the site. That is owned by someone else.
Well, so did they purchase just this portion of the
They
site?
just purchased the residential because that's what they do.
So they made a choice to purchase a portion of a site that has a total PD over the entire site.
They're a residential builder. They purchased the residential portion of the PD.
And so, okay, thank you. I think my next question for staff, then like, what happens in a PD when an entire, like, say, there's a PD over this entire area and a portion of it changes? Does that change the commercial? Like, do we now have like a PD, like theoretically, would there be like a PD over the commercial portion that was from the previous one and then that ends?
So we do have migration of PDs, especially on larger tracts of land where pieces shift and amendments take place. But the PD is dealt with in total. This is an amendment to the entirety of the PD, and it's only dealing with the section that's drawn. But that commercial component is still very much a part of the PD. The unified whole includes commercial development.
Would this completely blow up the commercial portion too? Or, so the commercial portion stays, it just ends at that property?
Correct. The commercial portion is still a part of the approved PD. What's being amended is only what you're seeing here tonight.
Layout of the road.
That's answering your question.
Yeah, I mean, that's another thing too. It's just like, we have this original design that was actually new urbanist design that, because I feel very strongly that there be commercial along this section of Atlanta highways, like it just needs to develop in a certain way, and this is not providing that support. So that's all I got to say.
Just a related question. Does the original PD provide for phased construction with commercial phase first?
So it depends how far back you go. There was a moment in this PD history where the phasing required, it was almost like bandwidths through the PD where there was commercial, multifamily, single family, all done as a phase. The second phase had a mix, is all part of that phase. And each phase had a mix expected. There was an amendment to the PD to kind of remove that expectation many years ago. So it's part of that sort of slow progression away from the original design intent. But yeah, that was originally anticipated.
But the way it is now, the current PD, if somebody
Not required.
on the whole thing, would they be allowed to build pod C first? And then pod B and then pod A if they wanted to?
Yes, the current PD doesn't have these pods, so it's just
Right.
But the current PD's layout, its phasing expectations were broken out by types of development. And did not require a component of commercial with each lift. I will say staff's comment regarding pod A. Pod A is the multifamily section there on the right, lower right. I don't have a pointer, but the reason why we looked, there you go. The reason why we were suggesting that that be done as part of commercial development was because of the various housing forms that are represented here. That's the housing form that is the multi-unit, single structure form that we have so much of. So our housing market has that represented already. The other options bring some variety where you could, I think an argument could be made that our supply is down. But that pod represents a supply that we feel like we have an adequate amount of in our market.
Okay. And so I'm just curious how, if ownership is in two different groups, how we can require them to do something that's beyond their power to do, to begin the construction of the commercial before they do pod it.
But I think that's a supposition that's beyond their power. So we do zoning. Project management lives outside of zoning. LLCs get created all the time to do developments. Different contractors, different development interests pick up their portion of the ball. They create a moment where they're working in concert. They finish the project and then they break up and do their own thing. That's very common in development.
Okay, I got you. Mr. Bacon, let me ask you a question. You said that D.R. Horton, does D.R. Horton own the subject portion of the PD, or are they just in contract to buy it contingent?
They currently own it.
They've completed the purchase of it.
That's correct. They've closed on the sale.
Okay. And so it's not the person who owns the commercial, is that the seller that sold D.R. Horton?
I believe the seller has sold the commercial portion to someone else.
To somebody else, okay. And oftentimes we see applicants, large developers come through with, they have land under contract, but it's contingent on a rezoning approval. So D.R. Horton proceeded to purchase this land, understanding that the current zoning only allows them to build what the current PD is. So is it fair to assume that although it's not their preference to build that, they're comfortable with the economics of that project?
Well, that's for them to determine. I can tell you that their contract was going to expire, so they had to make a decision. They had to go into risk, and that's the risk that they chose.
Okay.
Is that fair?
Thank you.
Mike. Yeah, I agree with a lot of what staff said, but I also keep coming back to, I think this is the third time I've seen this, and I've said it every time, that I don't like the use of alleys instead of streets, and I still haven't been convinced that that's a necessary thing, it just seems to increase density, and it seems to be a trade-off that I don't like, so I still don't like it.
I guess I'll just comment. I was going to say that too. I actually overpave, and so I kind of like narrower streets. So, taste different on that, I guess. But I was curious though about staff's concern about the alleys, and then the fire marshal says, "Yep, looks good to me. Approve without any concerns." Can staff comment on that, or do we have any fire representatives here who can?
Tonight, I think that's a really good question placed to them on where they find that comfort. I think it meets the minimum widths. Perhaps the applicant can speak to the conversation they had with fire marshal, but I think staff's reservation about this much alley being used for access to this many units, I think is written exactly how we intended in the staff report. It's a question of scale.
Okay. I guess can you just expand on that a little bit?
So as Stephen noted in the presentation, where you see courtyard developments or infill opportunities where they rear load the access to help with density and, to your point, pave less because they already have frontage on an existing street, or or they already have frontage on existing infrastructure, and the alley is just there to accommodate a vehicle getting to and from a garage. That's it. So it's appropriately scaled to be relatively small, and those developments tend to be pocket developments. So you may only see a dozen, you may only see 24 units in that sort of instance. And that's because you have that existing network around it to do the work. So when you have a site this big, staff's concern is the design is not developing a network that's going to function safely or with an eye towards livability. You do have green space. The applicant is correct, and they've indicated that in previous presentations. But you have these alleys that are going to be filled with trips, filled with activity. Yes, things might migrate to the green space. But the green space are these open areas here. So relax your eye. You see those moments of green space. Then you have these alley-loaded developed areas. I think that's where our source of concern is coming from, is the balance of green space to the density proposed seems to be a little off. It's not as optimal as we had seen in the previous versions of this PD. And I want to be careful too. This is not staff throwing a wish list or a pie in the sky sort of analysis on things. This is looking at an existing plan development and its merits versus what's being proposed to amend it. So just want to let you know, that's where our analysis is coming in.
Yeah, like the clear, like, this has quality, this doesn't have. Yeah, it's a clear comparison. And I just kind of think that the alleys instead of roads is a way to get around street ordinances by calling it alleys. It's increased density. And so if there's an ordinance for a street to have certain characteristics, then I don't think calling it an alley is the appropriate way to kind of get around and get what you want and not have to follow the ordinances for streets. Because these would be streets. I kind of see alleys are like, you have a street, you have an alley, you have a street, you have an alley. Kind of gives limited access to the back of properties for property owners, but the only way to access these properties is through alleys. You don't have any choice to have a street access. And I think then that's where these are really streets that are called alleys, so that they can make them smaller and increase the density. And I don't like that kind of just verb, that language change in order to get what you want and not have to have a street. That's my problem.
Yeah, I would say, it would be easier to support all these alleys if I was seeing more green space, but those limited green spaces between the townhomes are not really big enough for kids to kick a soccer ball around without breaking somebody's living room window. And, just looking at the site plan, they're just not wide enough. And so I'd find it a lot easier to be okay with using alleys as a street substitute if the payoff was, look, we made a little park in the middle of all these townhomes where kids can play. I think that would be a trade-off for public benefit that would be compelling to me. The single-family detached homes have yards. It's less important maybe up there, but in these townhome areas, if 6 of the townhomes were replaced by a little pocket park or something like that, I think that would be a much more compelling presentation to me in terms of the trade-offs between, like if the fire marshal's okay with the width of the paved surfaces, that's good enough for me. I think our fire trucks are, bigger than they need to be. And if they can still get them down there, then great. But yeah, I think a little more green space and a little more useful green space. There's not just, a 14-foot strip of grass between 2 townhomes facing each other would be more compelling to me.
Yeah, because when you look at it, there's not a ton of green space. There's a lot more alley space than green space. It's not even
park idea too.
Yeah, yeah. If you like the green space equal the alley space, that might be something. But that's a very narrow strip, like you said too. It doesn't even look like it. It looks like it's about as wide as the alley that you're getting as green space, and that just doesn't seem. I'd rather have sidewalks and green space along the road.
Yeah.
I wanted to ask the applicant about the ongoing litigation against DR Horton Homes that DR Horton spacing in other states from homeowners?
Sure, sure. So that is outside of my scope, right? I can tell you that that isn't necessarily representative of all of DR Horton's products, their culture, their work product. And that these projects are managed locally by local project managers and local contractors. So, yeah, but I couldn't speak to any litigation.
Can I ask if you remain the point of contact once those homes are sold? Do you stay that point of contact for the homeowner?
Engineering.
DR Horton Homes would not have a local point of contact for homeowners post.
You're asking if W&A or DR Horton?
Will DR Horton have a local point of contact for homeowners should they run into issues post sale?
Yes. Anything else?
Okay, actually, yeah, Mr. Bacon, regarding the fifth waiver from section 926-3B's requirement for all roads serving 4 or more units to be dedicated to the public. It says applicant's purpose is it allows some of the units to be oriented toward greens. Can you, with the laser, just show us the areas where that waiver is necessary to do the design thing?
Sure. Yeah. So in here through this network, I'd also, it's probably worth noting that all of these alleys are constructed to public street standards. So they may be called alleys, but they're constructed to a public street paving standard. It would be wide enough for a fire truck. So a typical road is 24 feet wide, face of curb to face of curb. That's why the fire department finds these today. Okay. So they're still wide enough.
Okay. So they're constructed to public street standards. I take it though, because of the curb cuts, you're not going to have on-street parking on these.
That's correct, because of the driveways.
Okay.
Right. And we wouldn't be able to do that in a public street scenario.
And
because of driveway ordinances.
And each unit has how much parking, in this area? Is it a car garage, 1 car garage with a?
Yeah, so many of them have a 2-car garage, and then enough room for 2 cars to park in the driveway. We all know that that's not really how that works, right? You fill your garage full of stuff, and then maybe you can get 1 car in there. So we think that you've got about 3 cars, parking spaces behind each unit.
Okay. So it's just that bottom left segment where that waiver applies?
That's correct.
Okay.
Yes.
And cars can easily pass each other on those alleyways.
Correct. Yes, wide enough for 2-way traffic.
So then what is the benefit of calling them alleys instead of roads?
That's a great question.
And driveways, right?
Yeah, here is the mic to get to your question, is that we don't have sidewalks. So I said public street standards, the paving section is the public street standards, I should clarify.
And then you have to have sidewalks and like.
That's right,
street
that's right.
trees and stuff.
So the alleys don't have sidewalks, they don't have street trees. Those sidewalks and street trees are in the courtyards in between the buildings, the town halls. So we've taken those sidewalks, those street trees that would have been located along a public street, and we moved them internal to the courtyard.
If these were all streets, then these townhouses would have, well, I guess they would have streets on both sides, or I guess, yeah. Makes sense.
It'd be really difficult to make the driveways work, the sidewalks and the street trees physically. Is that, no, how about it?
Yeah, I was thinking sidewalks and street trees.
Yeah.
That was what yeah.
Yep.
Other discussion or questions?
I think I've got a lot of disparate thoughts, so I'll try to get to something coherent. But I think in some ways this is a really, especially these 2 different, thinking about the proposal, the Lakewood proposal, also from your firm. And I really like that proposal, and I think it gets at a lot of things that we wish this would get at. But what this gets at, that doesn't as well, is these are more affordable. So like, there's a part of me that thinks like, you know, D.R. Horton's a huge builder. They gotta do better, like, it's gotta be better than this. There's gotta be a way to get, and this probably goes back to iterations of the PD, and so I don't know if it's realistic to get back there, but I'm just kind of struggling with not really knowing the economics of why you can't get that diversity, the housing typology diversity in one pod. It just seems like, I think that's what we all kind of want to see. And I know we're desperate for affordable housing, and I know we need affordable housing not in a multifamily high-rise or mid-rise type of thing. But I feel like that desperation shouldn't force us to have to accept something. This leaves something wanting for me, and I think you guys are kind of getting at it with the alley green space thing. And I understand that you have to have density to get that affordability. I do really get that, and I think it is notable that this has gone so many years, 21 years without being developed. So there is something about the economics of it that aren't working. I'm not really bothered by, I understand why a residential developer just has to focus on residential. That part doesn't bother me as much as I really would like to see commercial development happen on those front parcels. I get why this might have to happen that way, but I don't want our need for affordability to make us accept everything just because we don't want to, I don't want to be an obstacle for new housing getting built. But I feel like, you know, I like so often WNA presents us really great things, but I think in some ways the kind of products that D.R. Horton builds kind of ties a hand behind backs a little bit from a sort of urban design perspective. And so that's my sort of string of incoherent thoughts.
Yeah, and kind of piggyback on that a little bit too. I wonder, like, because what gets me about this is like, this doesn't seem like Athens. And I feel like I said that the last time it came up. Like this, you can plot this down anywhere. It's not part of a larger fabric of a community. And I wonder too, like, so my thing is though, I feel like we have some things on the table now that developers can use. Like we have the affordable housing bonus, you know, for like, you know, you can work some of that in. I feel like there might be a TAD that like covers this part of the county. I mean, it might not go out that far, but like there might be some other incentives to help make that work where we have a more designed neighborhood or work with the existing PD rather than just shoehorn in a whole other different neighborhood.
Yeah, I would just speak to that same vein in that I feel like this is the type of development that we see in a lot of our surrounding counties. It doesn't necessarily feel like the fabric of Athens as we've all tried to work towards, and we do have limited land. So I would be remiss to jump on something that helps us address affordable housing at the sake of a large parcel that we wouldn't have if something more innovative that could maybe address our concerns better comes down the road in the future.
So, Sarah, you hit it right, and I think the thinking is balancing affordable housing. They have jammed every bit of house space they can on this property, and that will bring the property down. But everything cycles, and I promise you, there'll be a day, we're not talking so much about affordable housing like we are now. There's going to be a day we are overrun with houses. Go through 5 Points right now, within about 4 blocks of 5 Points, there are almost $7 million houses, 7 multi-million-dollar houses. It is popping up everywhere right now. There are not as many buyers as there are sellers. So the cycle is happening. I'm not saying it's gonna happen. And again, a $5 million house doesn't mean all of a sudden we can buy houses at 150. But the more houses that are out there, that is what drives everything. So this would help, but I think it is definitely not the fabric of Athens, as you were saying. This is, you're looking at the back end, to put it politely, of a lot of units when you go through here. I think a little more help. Fewer houses, they can still keep the cost down, even if they had to rise a little bit to get more green space, do the roads properly. Not everything is an alley. Alleys are ugly, period. And I'm sorry, but whoever put this land together did it wrong. They didn't buy all the way out to Atlanta Highway. That's not Athens' fault. That is an individual's fault who didn't do their job, and now they can't do what Athens needs. So I don't see that they're making any effort except to make money. And we do need cheaper housing or more affordable housing. I think we can do that by doing this better somehow.
I'm just gonna make a motion to deny the master plan development.
Second.
Motion by Monique to deny, second by Kristen. I'll start off the discussion of the motion. And I'll just say, not everything, to me, not everything has to look like the, fabric of Athens. I mean, I agree, like this sort of D.R. Horton standard product is not something you see a lot of around here. And we need a lot more housing. I wish I shared Alex's confidence that the market has turned and that housing is going to somehow get cheaper next year and the year after that. We got a long way to go before it's going to be remotely affordable for the median family to buy the median priced home. And I think our supply shortage continues. Not to mention the fact that we're forecasting, 30 or 40,000 more residents in the next 15 years. So they need houses too that don't exist yet and are not on the drawing board. So with that said, I do think this project could be better. I like the old PD better. I'm happy D.R. Horton's here. I know they've got money and talent to build houses. They can make things happen, and we need that. But I think that this project would need to be better for me to support amending the PD, which I think, the old PD is better than the current thing. So I always think about what would happen if this didn't get approved. And we have a good, a PD that I think is better in many respects. It's been 20 years and it hasn't been built, so there may be something wrong with it, right? So I'm more than willing to entertain the developer saying, like, we need to make some changes to make this work. And that's fine. And if that means D.R. Horton's stock models, that's okay. I don't have a problem with that. I do think that in the town, in Pod B, I think we need more housing. Everybody needs some green space around them. I don't want people to have to get in a car to drive to a city park. I think a development of this size can support its local green spaces that thousands of people that would live here could use. And so I think maybe a small reduction in the density to provide, maybe fewer alleys, but still some alleys, bigger green spaces and some more green spaces. And then I think I could support it. And as far as the commercial thing goes, I'm persuaded by the applicant, they don't own it. And there's nothing in the existing PD that requires the commercial to be built first. And so to me, I feel like that condition would be inappropriate for us to, we can't make them do something that they don't control on land that they don't control. So I wouldn't, just for the record, I would not be inclined to support that particular condition. I guess that's all. Okay, other discussion of the pending motion.
I do want, I hope I didn't imply housing was gonna come way down in the next couple of years. It's not.
We're gonna hold you to that.
It's not. I'm talking 10 and 20 years. I'm too much future land use guy these days, and I'm looking 10, 20 years down the road. That'll cycle, not in 3 years. So everyone.
Thank you.
I was just gonna piggyback on that comment real quick, and I do appreciate the idea that, we have a good plan development in place now, and even though, in maybe it hasn't been built yet, but things can change and maybe 10 years in the future, they'll be able to build the PD that we like. You know? And it might be worth waiting for that better opportunity to come along than to just kind of take this opportunity. So, anyway, that's it.
Any other discussion or? Steven?
Motion to deny. Morales,
Yes.
Weiss,
Yes.
Beresford, McLaughlin,
Yes.
Pass, Sams,
Yes.
Sanders,
Yes.
Lord.
Yes.
Motion passes unanimously.
Thank you, Mr. Lee. Yep, yes. That brings us to your new business, we've already discussed with the two, so that brings us to item 3, 581 South Third Street, and I believe Lisa has an announcement to make before we go to staff.
I need to recuse myself from this discussion as these are my.
Here to, Stephen Higby's here to present the staff report for the special use request at 581 South Harris Street. Click on it. Thank you. And is requesting a special use in a commercial general zone. And simply put, they want to demolish the existing commercial restaurant, it's vacant, and replace it with a 29 space surface parking lot. There's not much more to it than that, as far as the request goes. Mark is not advancing again. Here's an aerial of the site. You have the UGA dorms right here, the high rise, the freshman high rises, Baxter Street along the top, and then you have Harris Street right here. This property is right here. It's right off the corridor. And I'll have some closer up pictures in a moment to help explain it. But you can already kind of see that the building takes up the whole front of the whole width of the lot. No room on either side. Parking is on the back, and then there's a couple of spaces in the front. So it's difficult to access that parking. In fact, you can't access that parking through this parcel. Future land use is Main Street business. That would not change. The zoning is commercial general. That doesn't change aside from the special use, and the whole block is commercial general. You can also see, if I go back to the aerial, that a good chunk of the lot of the block is parking already. This is looking at it from Harris Street. This is the front building. Either side of that building essentially touches the property line, so you can't get to the parking from in front, which is a major reason why this request has been made. And this is the parking. There's a brand new chain link fence here, so you can't access it even if you wanted to. The adjacent property is not granted access to this property, so there's no access. This is the proposal. We have 29 parking spaces, a stormwater facility to meet code. I will note that in the staff report, we have noted that one of the major issues from a code standpoint is that there's supposed to be a 10-foot buffer between the property line on either side, which would make this infeasible. So it can't be built as shown. And in fact, it would be very challenging to be built. It has to abide by that buffer requirement. So they would need a variance to do this. Staff notes in our analysis that this is incompatible with the 2023 comprehensive plan. Comprehensive plan calls for incentivizing alternative transportation modes, biking, walking, transit, incentivizing infill, creating appealing corridors. This is right off the Baxter Street corridor. This project would not meet those expectations. It is compatible with the future land use map and the zoning map because it doesn't need to change those. However, it is, in our judgment, incompatible with Main Street business, future land use character description, which calls for some of this Main Street style storefronts. The existing building is somewhat similar to that. So this is moving away from that character. I already noted there's not enough lot width to build this to code, so it cannot be built as shown. In the staff report, we laid out all of the special use criteria. We do not think the project satisfies those criteria. I'll call out a handful of them. The character and volume of traffic. This would attract more vehicles and decrease the appeal of using other modes of transportation in the area. Surface parking detracts from the architectural appeal of the neighborhood. It can decrease the appeal of building walkable redevelopment on nearby properties, which is desired on the Baxter Street corridor. It would also decrease tax value to pay for adjacent infrastructure. Parking lots are fairly low in their value generation, especially when you compare them to buildings. It is, from a staff standpoint, a lost opportunity, primarily, to add places for people to do business, to live in proximity to their daily needs, amenities, and educational opportunities in particular here. So we're recommending denial, and that concludes the staff.
Thank you, Stephen. This we will hear from the applicant.
Good evening, everybody. Hopefully I'll be quick. I know it's already late tonight, and hopefully I can present this to you and we can be the first approval for the night. Anyhow, my name is Patrick Perry I live at 355 Deer Trigger Landing here in Athens, representing Perry Planning on behalf of the owners, 581 South Harris Street. I got the owners here with me. They also own Jimbo's, the restaurant, the gas station next door. They're longtime business owners. They purchased this property. It was initially a restaurant, and then it became vacant, and now they're not able to lease it out because there's no, like staff's point, you can't access the parking lot. So we looked at things. There's a big need for parking in the area. So, we respect the planning staff opinion, but there's some other constraints, some issues I'd like to point out, in terms of addressing compatibility with the comprehensive plan. We are promoting a little bit of infill development, redevelopment, which is we're providing a parking lot there for people to come park. I don't necessarily is going to attract more traffic. There's already a huge congestion problem in Baxter, and we might make it, take a little bit of that traffic off. It's not much parking, but as the staff pointed out, it's a really small lot. There is a building there which is closer to the Main Street business, the future, but that building cannot be used. So we want to try to do something else with it. So we looked at options, and for the immediate concern, parking seems to be, a good use that's needed in the area. I reached out, the traffic engineer on this initially and asked him about his feedback, and he said, he would be supportive because it could potentially take some illegal street parking off that have a problem within the area. We're providing parking spaces for, businesses, University of Georgia students next door. Obviously they're driving the demand for parking. People, when people park there, they can bike to campus, they can walk to the local businesses, support the businesses. While it's not a mixed use development or affordable housing, nothing's gonna, parking lot now, nothing's gonna prevent this from being redeveloped in the future for, which is, for infill redevelopment, like is the intent of the comprehensive plan. Right now, the comprehensive plan, they want you to, the future land use is mitigates underutilization. Right now, it's a vacant parcel. The owners who are business owners pay taxes. They pay tax on this property right now. So the argument that, it's going to reduce the tax value by making a parking lot versus, a building, I don't think we should treat our property owners in Clarke County as piggy pigs. That's not really, maybe not the best way of looking at that. But, you know, from providing, you know, there will be more businesses, that will see maybe some more people can't use the businesses. Myself, resident Clarke County, I don't go to Five Points very often during school in session because there's no place to park. I'm sure the similar businesses in this area probably have a similar space. There's not businesses or cars. Not everybody wants to walk. Some people, you know, can't walk for some reasons. Some people need parking spots. We provide 2 accessible parking spots there for people to use, like per code, for people who can't walk. And we don't have bike parking. We got room for bike park, so we can add that. In terms of the codes, yes, we don't have room for the 2 landscape buffers on between the parking lot on either side, which would request a waiver to remove those because it's not feasible, given the width of the property, it's just not feasible to get any parking spaces, like it's shown. If you put a 10-foot buffer on either side, it's a 62-foot property right now, 62 foot and like a little bit of change, but if any buffer, that takes 20 feet off, you couldn't get parking on either side of it. So that would significantly reduce that. Right now, it's paved from property line to property line. If you're looking at the north side, you're looking at the back of a building. So we don't, you know, it's from screening for parking, the people are going to park there and they don't necessarily need the buffer. On the south side, it's currently paved to the property now. There's a parking lot on the adjacent property. So it's not going to look any worse. It's going to look better than it is now because we're providing tree canopy. You know, there's no significant canopy on it. We're meeting adding tree canopy to the site. You know, we're providing stormwater management. There's not any currently stormwater management out there. We're reducing impervious surfaces. All great things to do for the county. In conclusion, you know, I think this addresses existing parking demand. You know, reduces vehicle circulation through the neighborhoods and reduces illegal street parking. It enhances the usability of the site and provides for maybe some future redevelopment in the future if the owners are able to, you know, this works out for them, you know. And then it maintains, you know, compatibility to surrounding neighborhood. There to the south is parking, to the east is parking. There's street parking. You know, University of Georgia owns the property to the northwest, so that will at some point that could be a parking deck at some point. So this may not be forever use. I know parking lots are kind of like gas stations. They're not really looked at favorably, but this is, you know, I'd like to look at from a human scale. This is a local business owner. It's simple. It's not gonna aggrieve anybody. It's a fairly simple request. It's like Stephen said, it's a straightforward. We just want to put a parking lot. And we just thank you for your time and consideration.
All right, now we'll open it up to public comment. Is there any member of the public here wishing to speak in support of this effort?
Hello, everybody. Rakesh Gosai. I am co-owner of 581 said property. We run Jimbo's since 2014. In 2014, it was a rundown business, a gas station business. We obtained with my wife, and we changed the scenario of of the clientele nearby, UGA clientele. We had 90% boys shopping over there and maybe 5% girls. Today, at this, since of this time, we have 95% girls, they come to the store because they feel safe at that location. We have very good Google reviews. We are helping kids, who are looking for a parking, and 95% are girls at this moment. After every allotment of, new semester, the parents who don't get parking at, anywhere at UGA allotments, like allotment 1, 2, and 3, the phone rings constantly. I am out there. I am working from 7 to 11 to 10. I don't eat breakfast. I don't eat lunch because I want to help them. I don't have 10 to 5 job. I'm there for a community. I have a daughter. She's 26. And I have a goddaughter. She's 22. And I can't see these kids, parking 4 streets down in the dark alley just because they can't find a parking. And I have parents who are crying when they're when they're dropping their kids, they're crying. They need parking for the kids, okay? I understand that out of state kids not supposed to have parking. I mean, they're not supposed to have cars, but there are kids who would travel 1 hour drive, 2 hour drive, 3 hour drive, and they want to go back for Thanksgiving and, their dentist appointment, and they need the car, and all the parents are not able to support. And I feel bad for them. I wish I can accommodate like every kids, who are looking for parking. And summertime, it's 100-degree, like figure of speech. And they, UGA sometimes don't give you parking where you are. They give you like 5 miles down the road or 3 miles down the road. And they're walking in the heat. And these kids are suffering. And now it's raining every day, like day and night. 10 years before, it used to rain for 10 seconds and it will stop. Now it's pouring all night, all day. And it's humid. And, I'm saying is like, I want to speak more. I see the red light is on, but I want to speak more, if you allow me to speak more.
We may have questions for you and invite you back to the podium during our discussion.
Thank you for listening.
Is there any other member of the public here who wishes to speak in support?
I would. My name is Frankie Consign, and that's my husband. And this is the property that we purchased with the intent of having a business in Athens, a second business. But at this point, we're getting denied for just being denied because it's not the right business. What is the right business here? Everybody has a different opinion about what they want as a business. And we decided that we wanted to have a parking lot. There's a Cane's restaurant that's right up the street that has a problem with parking. And there's illegal parking next to us that they're putting boots on cars all day long from people who come to Athens to eat or to come and visit Athens. And then when they come out from eating or visiting somewhere in that area, they have a boot on their car. How do you think that feels if somebody comes to Athens to visit and then that happens to them? And you're saying that parking is just like like something bad. Who all drives a car here? Does everybody have a car? Is anybody on public transportation? So what's wrong with the parking lot? When you go to a restaurant, there's a parking lot. When you go to a store, there's a parking lot. I just want to know what's so bad about a parking lot. Really? You just have some compassion about people that want to own a business or something that they want to do. It's not that we want a restaurant. It's not that we want to, I don't know. But if you can come up with some kind of idea that would work for Athens, that would work in this space with no access, we would appreciate it. Thank you.
Thank you, ma'am. Is there any other member of the public here who wishes to speak in support of this application? And is there any member of the public here who wishes to speak in opposition to this application? All right. I guess we'll bring it back behind the rail and who wants to start?
Go ahead.
Well, Sarah, I'm glad Sarah and then Alex. Yeah, go ahead. I defer. That's fine. I just saw Sarah first. Yeah, no, that's fine.
A question, I think it's more for staff, is how did this happen?
That was my question. So.
And honestly, the applicant may be in a much better position to speak to all the intricacies of purchase of the property and the agreements that predate their purchase and the agreements that timed out during their purchase. But you have a series of landholders over time that made a variety of uses out of this property and subdivided it. And there were some agreements, again, that predate their ownership by many, many, many years. Some of those agreements were memorialized and were tidy and able to be tracked. Others were not. And because of that mix, we have the current condition where once there was some commonality to the access and the flow. Some of you may remember when this was Locos. Some of you may remember even before that when it was Wishbones.
That's it.
There was.
I remember that.
Yeah.
I was sitting here trying to remember what it was.
Yeah. So there was a lot of freedom of movement across all of the parcels that you were seeing on the screen. It was uninhibited because there was some commonality in ownership and there was also some shared financial understanding between all of that. Over time, that ended as properties transferred. The whole was not purchased and the person who had control was only selling off parts. That person has passed and now we have property that's in a state, which also makes it complicated.
And that is the subject property or the
No,
adjacent ones to the
adjacent,
south?
adjacent.
Huh.
So the areas where you would have to cross where the fence is now, where access is restricted.
So the fence is along that on that photo at the
Correct.
bottom.
Yep.
And who erected that fence?
The property
Of
of,
those
not
other
the
properties,
applicant, but
The
yes,
other people.
And the other property owner is an estate.
it is now.
And what's the deal with demolishing that building? What would the process be to do that? Would that just be a straight demolition request?
It's largely an administrative review. Given the age of the property, it could be subject to, it would be subject to the mayor, to the commissioner who represents the area responding about the removal of something that's 50 years old or older. Which is very common around the community, that process. But should that commissioner agree that demolition can proceed, then it would be all administrative at that point to move forward with the removal of the building.
Okay.
Sure. Well, that was my main question and I figured that it was different. And I actually remember, and I cannot think of the name of before Wishbones or whatever. It was something different when I was in college, but I will say, and I've been to that building when it's been whichever restaurant it was at the time, and you don't realize the property next to it is not the same property. You pull in there, you park, no one cared, previous agreements apparently, and everybody was getting along. As far as obviously can't get a park, they can't do anything with it right now. I mean, am I missing something? Like there's a parking lot you can't get to. Could they get to the parking lot from their other property, which still doesn't solve it because you can't always count on them owning both properties, but.
They could enshrine it, in some sort of agreement that
Yeah.
carried over. Yeah, is there anything stopping? That was gonna be my question. If they own the property in front of it, is there room there to connect to that back parking lot?
Some topographic issues.
Can I just ask the applicant to come back to the podium to address that question?
Yeah.
I understand part of the basis of I was gonna ask a similar question. You cannot access the parking behind the existing building.
Yes, sir.
Because an agreement has expired, but can you not, I think it's dumpsters that are located in that area next to the gas station up there. Would it not be possible for you to provide access to across your other parcel to that space?
So we own the business, not the land of Jimbo's.
Okay.
And the tanks, underground tanks are involved over there by the dumpster area. So and there's a height, like there's a height, yeah, retaining wall, like, so it's like a big, it's a big dip over there. And then this property, this fence is 1 foot inside our property. And when I asked Mr. Cartwright, he was suffering from cancer and he just said like, I have few days to live or something and I will fix it or something, and then he never fixed it. And then he passed away and we didn't want it to give him hard time at his condition and at his old age. So we just thought like, we can just erase the whole slate because I don't know who made mistakes. How did this happen? There's an encroachment, on the property, like by 3/6 inch or there's a bracket version on the property, like which is he was awarded like $500 back in days. Just the toenail, the foundation of the wall is in the foundation. There's a brick foundation wall. Do you have a picture of the Steven, sir? Like I don't know. Okay, so he painted a nice mural, like UGA mural, the whole mural without our permission, and and then we said we're gonna let him do because we have other plans for the property. So let him live his last few years or fighting his cancer or like the dream. And we had different kind of a plan that we're gonna erase this whole thing because we don't know how this encroachment happened. We don't know how the building don't have access like easement, and then we thought we're gonna just erase the slate. And at this moment, we will go with the parking lot, and maybe in the future, when a better opportunity come, like we are trying to acquire Jimbo's property and it's in process, but it's delayed right now. I mean, we don't want to make any promises that we can do from the front or back, it's just like we want to erase right now. Maybe in future, we will come with a better plan, then we'll be here again. But at this moment, our main concern was to erase it, make it a blank page, and then the encroachment, we can give it back to them, whatever is their side. So we did the survey and everything. And, so we can have a fresh start, so we don't have to come back again for encroachment issue or something else like easement issue or something like that.
Questions?
Yeah.
Since you're up here, I'm just curious, when you purchased the property, was the original intent to open another restaurant in the space?
So that property was already rented to someone. I know the name, but I don't know if it's appropriate to say or not. It was already rented. It was generating income. Yes, they never paid us rent till the lease expired. So we have judgment. We have attorney involved, and then we have a collection attorney like chasing them, right now.
Right.
So we didn't knew that the property didn't have easement. There was encroachment on the property and all that subject. It came on the next stage,
Were the parking issues happening while it was the restaurant when you owned it and they were leasing it from you? Were there the parking issues there?
No, they had a contract with Mr. Cartwright, not with us. We just jumped in the flow. And then when the lease was expired, then we got reality check that there was suddenly 1 foot fence installed.
Was with the previous restaurant owner, but now that you have property, it's not.
Yes, ma'am.
It's not your agreement.
Yes, ma'am.
And so the parking lot idea is now the result of, well, this is what we do with the property.
We get 1,000, right now, as of today, I have 30 requests for fall parking as of today from parents. And as I told you, like 95% are girls. You guys can come anytime, check my books. You will see all, and as I told you, I'm a family man. I have daughters. Some of you have daughters, I mean, I don't know what is the appropriate way to speak here, but if it's a boy, I can tell him to go behind the building and pee, or go like 4th Street downs and in the dark alley and park his car. But when the girls come, I have a very soft corner. I want them to be safe. I want them to come as they are. So our business is like a different, it's like a college-based business. We don't have certain demographic things we sell. We want them to be as comfortable as they are. We install cameras on Jimbo outside so we can watch them. We can be, they can be safe. And then I think we can do a community service for 29 college kids. They are going to college and, taking off from there. And it's not about money. It's about helping the cause, helping, a certain demographic.
Thank you, sir. I appreciate it. If we have more questions, we may call you.
Thank you.
Back up again. Can I just ask a question of staff? This is not a historic district, right? So if the applicant wanted to apply for a demolition permit to take down the building that's currently on the site, there's no impediment to them doing that, except you said before that the commissioner for this district would have the opportunity to press sort of pause on that?
Yes, so there is a demolition review process that precedes the issuance of a demolition. If a property is 50 years old or older, and it's meant to deal with the undesignated properties and to provide an opportunity for a commissioner to have a moment of pause, look at something to see if it has merit for consideration. Then they would inform staff whether they have a concern or want something studied, or if they're okay for the demolition review to be completed so that the applicant can get the permit. It is really just kind of a pause. I'm not, honestly, as we're sitting here right now, I'm not really sure about the status of any kind of demolition application for this property. But the age of the structure, talk 50 years, these days, we're talking about things that feel like they're relatively recent builds. I would imagine, and what we do, we go back and we look at aerials and we kind of verify what is the vintage of the structure. I feel pretty certain this would be 50 years plus from its initial construction. So we would communicate with the commissioner would communicate back, and then we would move forward with whatever information we receive.
Okay.
This is the special use for the parking. It's not the demolition.
That's right.
Demolition is independent. It's the special use to use the property as parking.
They can demolition it, but parking issue that we're talking about.
Yeah, okay.
Alex. Two things. I'm going to ask you a question as staff in a second, but neither of my daughters had cars in college. Well, one is a senior and they're 3 hours away. And I go pick them up at holidays and bring them back. But there is a major car issue, parking issue, and I mean, it's a big issue here in Athens, and I get it. So it's not like we don't need the parking space, but you don't have to give your son or daughter a car to go to college if it is possible not to. And I'm proving it every day. I just partially selfishly, I don't want the problem of a child to have a car that I got to go figure it all out. That's my business. But the thing that's bothering me the most, so even if they demolished if they couldn't do a parking lot, if we denied it and they they can't use the business as it is realistically, if I'm understanding. So if they tore down the building, they don't have much choice of moving it either, do they? Or do they? That's my question. What can they do to put a business back on that property?
So the way our standards read, you can't have parking between the building and the street. So that's a place to start to answer your question. They have a very small amount of parking, as you can see, between the building and the street that would be legal and non-conforming. But if they were to tear down the building and absorb the expense of removing a structure to then build another structure, they could seek a variance to having to waive parking between the building and the street standard. The building could be constructed at the back of the property and have all of the parking front loaded. And the hearings board could hear that request, and I would imagine part of that application would be the circumstances that we're seeing here tonight. Whether it's issued or not, it has to meet all 5 criteria. Is it a hardship? You know, that analysis would have to take place as part of that. That is a pathway. But that would be the only way that I can imagine without an off-site parking agreement to provide parking on-site and have a use that is not a standalone surface parking lot. Another option, I mean, that's for commercial use. Another option would be some sort of multi-story building where the parking is in the footprint of the building. That's not an inexpensive development proposition, but you know, if you took the layout of the parking lot and you'd still have to seek the waiver for the setbacks. You know, if you started to build up, you'd be right on the property line, you know, in order to make the footprint of the parking work in the footprint of the building. That's what I'm trying to say. So it is fraught, right? The only way to get it to function and meet code entirely, you would only be getting a handful of parking spaces. And you'd get a very long linear building that may not have the depth to really lend itself to something that's immediately useful.
Thanks.
So they still have to get a variance to build the parking lot that they have.
This design.
Yeah, yeah, or pretty much, well, they could build a much smaller parking lot, I guess, with a lot fewer spaces.
Half.
Yeah, half as many spaces. Yeah, because I see that as a real challenge too, getting a variance for, that might be tough just for a parking lot. Might be easier to get a variance for a building setback with some parking in front rather than just a parking lot. That's just from my experience on the airport.
So does the person have to, like, my property, I would have started with the demolition permit. And I guess what I'm not really understanding is, let's say I wanted to use it as parking lot. I saw that as the only use that made any sense economically and logistically. You start with a demo. Can you use your land as a parking lot, even if you haven't had it? So you would get cited for that because you can't have cars parked on.
Even if it is a parking lot.
Well, once the building's gone, you've lost the principal use.
Yeah.
So then the parking becomes the principal use, which is a commercial parking lot. We're right back to this question.
I've seen cars parked on like the Holiday Inn site where they tore that down, right?
But are they just parking there for free? Is that, or is that like a paid lot?
Yeah, what's the legal status of that?
That's a separate issue from this item that's in front of us.
Yeah.
But it has that applicant, it has that
No
property
permits have been issued.
sought a permit.
No permits have been issued.
Okay. And is that something that we would ordinarily expect code enforcement to cite?
That would be something that's subject to compliance with code. Yes.
Okay. Kristen?
Yeah, I sympathize with the owners, because it's a weird property and I understand how the access issues happened. I think it's unfortunate that there wasn't something when they purchased the property that specifically stated that they had access to that property, because that's just key in all of this. What really gives me pause on letting this be a parking lot, aside from what we talked about earlier in this evening, is because never mind the building. In this case, the building to me is a non-issue. What gives me pause is that right next door is another parking lot that's paid parking for presumably students, I guess for anybody, and then directly behind it is UGA parking. And yes, as a incoming parent to a freshman who has told her daughter, no, you cannot take your car to college. I mean, honestly, for up to me, UGA would not allow freshmen to have cars, period, but this is not my battle. Normally I try to fight it. So yeah, I just have a really hard time supporting this, just because I feel like this should not be our mess to clean up, to put it very bluntly. this is a land use issue, and we're talking about all the different parking lots that are already in this area. And I have a really hard time supporting another parking lot, for 29 spaces. That is really not my battle to fight, I guess, so.
I'll just say that I'm very sympathetic to the owner. You know, whoever put up that fence is not a nice person, especially putting it a foot into your property. I would have just taken it out, but there doesn't seem to be any. Yeah, it's a hard solution. I don't know if a parking lot is the best solution, because I see a lot of challenges in getting that variance approved. You know, that's going to be a hard one. I don't really see a good. It could be other things. But yeah, I'm definitely super sympathetic, and I don't know what the it's a mess for sure. I don't know what, yeah, I don't know. I guess that's my thought. Much of a thought. Sarah.
I think right now, for me, I'm inclined to support it, even though I'm inclined to support it because I think that I think that's the beginning of a set of problems that are gonna need to be solved. And I think ultimately, like what I think I would wanna do is try my hardest to acquire that front property on Baxter, combine the two properties. I think that would maybe help, because my concern is that we say yes to a surface parking lot, and that is what I'm inclined to do, but I think getting a variance for that buffer is so hard to get, and so part of me just wants to kind of remove an impediment to at least moving in that direction. There's no, unless somehow these parcels can be assembled, I don't see a solution. And I don't have a particular, I don't, it's not important to me for that building to stay up. I don't know what the condition is, but I never thought it was like some amazing, I think it's barely historic. So that's kind of where my part is. It's a sea of asphalt. And yes, I would love to see that whole kind of block be built out differently. And the first step to doing that would be to get rid of that building. And I know we're not deciding about the demolition, but you could see as an owner, you might not want to demolish the structure if you don't have a good pathway for what use you would have it be. So I don't know. That's sort of my feeling about it.
That'd be kind of the beginning of sort of revitalizing that parcel or that little area.
I think so. I think I would have maybe wanted to go about, I would start with the demolition permit. To me, that's sort of what that might be the order I would have done things in, but that being said, the building being there really illustrates the problem. If the building were gone, it would be, you would be able to understand how this weird property ownership situation created this. So.
Yeah, I'm on the fence too. I mean, I think I'm like Kristen and Mike said, I'm very sympathetic to the owner's predicament. It's unfortunate, the situation they're in with the divided ownership and so on. And like Mike, I would have cut that fence down the minute it went up. If it was,
Cut it down, it's on your property.
it's on your property, I think you're allowed to just cut it down. We put it there and it's yours now, and you can remove it if you want. But of course, they could put up a fence on their property and you still wouldn't have access to the back. So, but as a general matter, you know, as we talked about on an earlier item tonight, surface parking lots in particularly commercial downtown zones, right? But in any commercial zone, it's not a land use that is generally good for the county. There's a great deal of parking around there, and if it's supporting a principal use like a restaurant or some other business, that's one thing. But if it's pure parking, then it's bad for you know, the streetscape and stuff like that. So my general bias is against them. This is a very specific situation where maybe I could support making the rare exception Again, partly because that building doesn't appear to really have a productive use, the access problems that it has, which is very much not true of the other application we saw for an SUP for a park, tonight. So, yeah, I think this is a very difficult situation. And before anyone's even made a motion, I'll just remind the applicant that we're nothing more than an advisory body, and that is to say that we make a recommendation, and then it goes to the mayor and commission the following month, and they make a decision. And so, regardless of what the outcome is here, you know, it's not a decision on the proposal. It's just a recommendation to the mayor and commission. Alex, and then Monique.
So I'm right along with actually what the two of y'all were saying and what we're saying. Normally it's a quick and easy, no, you can't tear something down that parking lot. This is an absolute mess that will not get itself cleaned up. I'm actually not sympathetic because when you buy a piece of property, you need to know how you're going to get on it. And that was due diligence that isn't the county, Clark County's problem, but it is a mess. I don't see this doing anything but rotting down to nothing, because we possibly have a dispute going on and it's just going to sit. And while I don't like tearing things down and building parking lots. There's a song about that. And I'm along that. But I'm inclined to vote in favor just to get something done there. Because when that building's sitting there, this place is not good for Athens. And I would say this, it would be an exception for me to vote in favor of it, but I'm leaning in that direction.
I'm also leaning in that direction, but I wanted to get some clarification on how you currently use the space again. I know you said it, but I just want to get some.
We're not using any space.
It's not used at all.
Every day we have, every week we have 3-4, prospects, like they want to rent the space. There's no easement, no parking, and they run away to some other, there were UGA alumni like from I think Olympic teams or something, and they wanted to open a fitness center right next to the UGA, and there was no easement and they couldn't obtain it. Then there is a yoga studio, they want to come over there and they couldn't obtain it. And every third day there is somebody coming and there is no use to that. There's no parking. We can't sell. From last 3-4 years since we obtained it, we just paying mortgage and taxes, and trying to, landscaping, and we have to access on the back of the land of the parking, we have to clean up, and we have to access through the UGA, And right now, while I'm standing up right now, Jimmy John is looking for 4 employees parking because the drive-through through Jimmy John, I think Jimmy John, one shift is like 7 people working. There are 7 employees already, then 3 drivers, 4 drivers. Ponko's Chicken, they couldn't make it right next to UGA, like right next to Jimbo's. There's a Ponko's Chicken, they couldn't make it. They wanted to sell their franchisee to 3 brothers, and they were looking for 4 parking lot for their employees because there's not enough parking on that. I spoke to Mr. Harris Scott, 573 Baxter Street, the one between Raising Cane's and Jimbo's. And as my wife said, they just utilizing a booting company, because lunchtime there are 12 people, they park over there and they walk here or they walk there. And there are people like they go to
I'm going to stop you.
While I was standing here.
What we can do at this phase is ask you questions and hear the answers.
Sorry,
to the questions.
sorry.
Not an open.
I just got carried away, sorry.
That's, thank you.
Sorry.
And make a motion, or you were about to say something, Mike?
No, that's okay.
I'll make a motion that we approve that we approve this.
I didn't remember what I was gonna say. Can I say it real quick?
Let's see if we have a second.
Okay, then go ahead.
Part of the discussion. Okay, motion by Sarah to approve, second by Alex. Discussion of the motion. Mike?
No, I just wanted to say, like, they have to come to us first, right, before they can get a variance on the property. So we have no idea if they're gonna get a variance.
So the variance, if completed, these special use applications, you can request variance. It needs to be in your application. So that's what was not in the application, was that ask for relief on the buffers on the north and south sides.
Okay, but they need us to give the special use before they can apply for the variance,
It
or?
can be done concurrently, they just have to be requested.
Okay.
They weren't, so that's.
They'll have to.
So there's not like, we wouldn't
Around
know
with
that.
that.
So.
Did we request that they request it?
Could we add that as a condition?
So you can, so the challenge is, and this, I don't want to sound overly bureaucratic, but the variance request gets evaluated. The staff report would reflect that evaluation. We use the variance criteria to do that evaluation. All those things are not part of this because it wasn't requested. So you would be making a recommendation to include that and say that you're okay with the design as presented, would be doing so without the benefit of that evaluation and going through the criteria.
Because they might be sympathetic as well, and, even though it might not be, so might still grant the variance if the applicant is
and I know
persuasive like he has been for us, maybe,
we're at 10:15, but if you were to do that, my advice would be, and I'm looking at Austin and John when I say this, you would need to provide that evaluation as part of your deliberation. Like the record does need to show that the variance criteria was considered. We can't just throw a condition saying it's okay.
We like table it and then let them decide the variance and then we look at it again?
Further development of the application to include the variance request would be.
Because then we know, because, we might be approving a parking lot that they're never gonna, they can't get the variance anyway, but if they can convince the hearings board to give them the variance, then it seems like it would probably be a lot easier decision for us, because we're like, oh, well, now it's actually a possibility instead of just a theoretical.
It really isn't something that will go to the hearings board. You have a binding site plan. So the hearings board can't unbind the site plan. See the conundrum.
What Bruce is saying is, as part of the special use, you can grant the variance, but it has to be, it's part of the binding site plan, but for this body to do so, you need to consider all 5 criteria, and you need to be in the staff report and those things.
So we can actually grant the variance as part of this process, is that what you're saying?
No,
Yeah, I think what you're.
I'm saying the opposite.
Okay.
When,
Can I just say, you can, it hasn't been requested. Bruce is saying table it, allow them to request it, come back to this body and then proceed, I believe.
Okay, I just heard the motion.
That's what I was gonna make an alternate.
Just amending her motion, so let's.
So I think I would like to recommend, or I would like to table the application in order to give the applicant time to more formally request the variance.
I'm glad I remembered my question.
Alex, you seconded, is that amendment to her motion?
Is that an amendment? Can that
Or is
be
that a
an
new
amendment?
motion?
You can go for a motion.
It's a substitute motion.
Substitute, okay, not amendment. I could have seconded that.
Okay. Okay, substitute motion by Sarah to table this application to permit the applicant to amend their special use permit application to request the necessary variance, seconded by Kristen. Any further discussion of the motion, or are we ready for a vote?
Who's the second?
Kristen.
So, wait,
Discussion of
can
the
I
motion.
still have discussion?
Of the motion, yes.
Yeah, because yes, in between that. Okay. So I'm still trying to get this part right. We could not vote this with the original intent of, and let's say we voted in favor. That's the example I'm giving, to approve for them to have a parking lot. they can't then go back. You may have said it, I may have just not heard it right, I apologize. They can't then take that win and get a variance and come back with a variant. Can they take the win and then apply for a variance? Okay, so that's the part I just did not hear right. It can't be done in two steps. It has to be done in one step.
It falls apart because this is a binding plan. So.
Okay, all right. That's all I need. I wasn't paying attention. It wasn't sticking in my head that this was a binding plan. Got you now. Okay.
Okay. Stephen, are we ready for roll call?
Motion to table. Morales,
Yes.
Beresford. McLaughlin,
Yes.
Pass,
Yes.
Sams,
Yes.
Sanders,
Yes.
Lord.
Yes.
Motion passes unanimously.
Thank you to the applicant, and we'll move on to our next item. It is 1075 Gaines School Road.
I was here for my brother.
Say yes.
All right, I'm back again here. Streak. Ask here at 1075 Gaines School Road is to rezone the property from commercial neighborhood land development to commercial office. Remember that is flipped. It's commercial office PD and should be going to commercial neighborhood. This would also dissolve or remove the property from the planned development. So we are both changing the underlying zoning and withdrawing the property from the planned development. Land development portion that is on the adjacent parcel at 1065 Gaines School Road, the church property would remain. The applicant has indicated on their application an interest in building commercial retail, but they do not have a concept plan. There's no binding plan associated with this ask. Here's an aerial of the site. In the heart of the east side, we have Gaines School Road coming here. We have Barnett Shoals going off screen towards the top left, and then Barnett Shoals across here as you go down the bottom. Just off screen to your left is the Publix. The Chick-fil-A is right here. We have Aldi up here at the top right. Hope that gives you a general idea. We have a Covenant Presbyterian Church next door. This is one of the entrances to the Green Acres subdivision. And we have a office building on the parcel right now. This is the future land use for the area. It is general business. It would remain general business. The zoning on the left is COPD. On the right would be CN. You can see we already have CN in the area across the street and down the block. So it is in the neighborhood. It would not be a spot zone. This is one view of the property. I believe this is from the church parking lot. See, you've got some trees, a canopy buffer there. This would be from Greencrest. This is the driveway that is shared between this property and the church. This is a view from the front of the property looking towards the intersection at Gaines School Road and Barnett Shoals. Staff views the request as compatible with the 2023 comprehensive plan, which favored redevelopment instead of greenfield expansion. We want to make use of our existing parcels where we already have infrastructure. It is compatible with the future land use map, doesn't need to change, is compatible with the zoning map. CN zoning would allow more redevelopment flexibility and allow more retail opportunities that are prohibited in commercial office. We are recommending Approval with a condition, however, that no drive-through uses shall be permitted on this parcel. However, this condition shall not preclude standalone ATM, similar style kiosk. And part of that reason is that this is right up on the intersection, and putting a curb cut close to that intersection would interfere with traffic operations and traffic safety. So that's why we're recommending this condition. That concludes the staff.
Thank you, Stephen. Next, we'll hear from the applicant.
Thank you all. Alec Leslie, 918 Glenbrook Drive in Atlanta. Yeah, thank y'all. Y'all should all be paid, by the way. I'm exhausted. Nonstop.
Make a motion.
We get $10 a
$10 a meeting.
I mean, basically for this, from commercial office to commercial neighborhood, I mean, it will go with the uses in the immediate area. And I guess the main reason why is that CO, we're maximizing building square footage of 2,500 square foot. We're not trying to hide or do anything funny. We just don't know what we can put there until we know what we can put there. Like I said, the buildings we'd be doing would probably be about 27 to 3,500 square feet. And we don't know if we can do that until we know what we can get rezoned. So that's the reason why we haven't disclosed any site plans or anything. We just honestly don't know what we can build there. We're fine with the conditions. The one with the drive-through, I don't oppose. I mean, I know that even if that condition wasn't on there, we still have to get a special use permit to get a drive-through. So, but our uses are not going to need a drive-through. So I'm not opposed to the conditions. The existing curb cut with the church, everything's perfectly fine with us. I recommend approval, and I appreciate it. But yeah, I mean, that's it. If you have any questions, you ask me whatever you want.
Thank you, Mr. Is there any member of the public here wishing to speak in support of this application? Or in opposition to this application?
Hey, I am Melanie Aaron. I'm 65 Clyde Road, Athens, Georgia, which is in Green Acres. I grew up in Green Acres and now I'm back with my mother, who's widowed and has a few little issues, nothing major, thank God. What is not like, which of these things is not like the others? That corner. Corner, left side, Synovus, they've got a lot, an extra lot that's landscaped on Greencrest with existing trees and landscaping. They've got an exit there, but they've also got one on Barnett Shoals. If you ever pull up there getting out of the neighborhood and you see 4 cars, you're like, wow, 4 cars. You know, it's not a heavily trafficked, thing with the bank there. The one across the street, Bank of America, it's got a Waffle House behind it and offices on the other side. The other corner, Walgreens, is surrounded by like shopping center type stuff, pizza restaurant, coffee shop, shopping center, all that. This corner, basketball court covered, which children are at all the time when they're able to, right there. Church on the other side, which had their food distribution today, where they are, which is very popular and needed. They back up down Gaines School on the turn lane. People are lined up down that almost to the entrance of Aldi usually, and you have to skirt around them to get into the neighborhood. It's a very community-oriented church. That drive is shared back up in there into the church. I don't see how you're going to not have parking issues there, have entrance issues, possible traffic as per the traffic department, Traffic and Public Works of Clarke County said there's going to be heavy queuing of traffic at the intersection. I don't know how you're going to get delivery trucks in there. If you rezone it to CO, that would allow for laundry facilities, dry cleaning, vehicle repair, restaurants and bars, convenience stores. You're going to have a lot of traffic. And that's part of the intent, when you want to make money but you're going to have traffic, I feel, backing up into the intersection, trying to come in there and turn left into this. as people are trying to leave the neighborhood, because that's our main entrance and exit. There's two more. One of them has a light across from Kroger. A lot of people choose not to use it because you've got an issue there with a light coming out of Kroger and having to, oh, are you going next or I'm going next? The other entrance has no light and it's got traffic, to me, danger problems. I used to drive 40-foot buses for UGA. I just don't see how you're going to get delivery trucks in there, you know, food delivery trucks or whatever kind of supplies you need for certain kinds of those businesses. Where are people going to park? They're going to spill over into the church, or are they going to, you know, take up whatever, or maybe on Greencrest? That's my final thought.
Thank you. Is there any other member of the public here wishing to speak in opposition to this proposal? All right, that concludes the public comment portion, and we will bring it back behind the rail. Who wants to lead off? Yeah, Kristen.
So I feel like this property is continuing a trend of properties on this part of town that are heavily wooded and also commercial. So I honestly, I think it makes sense to make it a little bit more commercial. My concern was more about like a buffer with the neighborhood. So Bruce, maybe you could tell me what kind of provisions are in place that would have to be followed for like along that property line where the houses start.
So that would remain in the PD. So that's.
The driveway is?
Yeah. The driveway, I don't, if we've got a view that would better show that. Okay, so that driveway right there is shared between the church use, church access to the rear of the church site, and office function requested to be retail function. That curb cut would remain. The PD is going to stay on the portion that's to the right of that driveway. So the pavilion there, the covered basketball court, and all the tree growth there is remaining unchanged.
Okay.
I have a related question. Can you go back to the zoning map? Yeah, that's good. So that first purple parcel in behind the subject parcel, that's the one with the driveway to the church and that covered pavilion and basketball court. So there's not a residential use that the subject parcel abuts.
Correct.
Okay. Okay, thank you.
And so the driveway comes up. Where's the driveway in terms of the property line?
Where the arrow.
Second property, right?
Is it?
It's
right along?
Shared right along.
Okay, at where it hits.
Down the middle.
Where it hits the right of way, it is split, and then the property line takes the jog, and the rest of the drive is on the church's controlled property, the CO property.
Okay.
Where it meets Greencrest, it is split.
All right, that's cool. Okay. All right, that was my only concern. Thank you.
I guess I'll just jump in and say that this property fronts on Gaines School Road at, you know, in an area that's predominantly commercial. And so the commercial neighborhood zoning feels very appropriate. Even, you know, commercial general zoning would seem appropriate, given that it is on one of our primary corridors on the east side. So, and, you know, I understand neighbors are always concerned about traffic, and that's a legitimate concern, but it looks to me like the driveway is just using the measuring tool on Q Public. It's over 200 feet back from the intersection on Greencrest here. And so, you know, it's so far back that the idea of cars getting stacked up or being unable to get in and out of there when the light's red strikes me as quite unlikely. And so this seems like an easy yes to me.
Make a motion for approval
A motion for approval by Kristen
with the condition provided by staff.
with the staff's condition. Second by Mike. Any further discussion to the motion? Okay, Stephen, will you call the roll?
Motion to approve the condition. Morales,
Yes.
Weiss, Beresford,
Yes.
McLaughlin,
Yes.
Pass.
Yes.
Sand,
Yes.
Sanders,
Yes.
Lord,
Yes.
Motion passes unanimously.
Thank you. That brings us to item 5 under old business, and that is, I'm sorry, new business, and that is 155 Whit Davis Road. All right, good evening, Commissioners. 155 Whit Davis Road, we've got a rezone request here. Click on the screen. Thought I did it, but weird sharing stuff. Thank you. Okay, so we've got a commercial neighborhood property looking to go to mixed density residential RM3, our most intense mixed density parcel. The future land use is general business. There's general business along that corridor. I will show you that. So no change needed. They have a non-binding plan for a multifamily development on this lot. They're showing 52 apartments and 80 beds within those apartments. It's a mix of 3 and 4 stories, and they are seeking affordable tax credits. So we have the parcel here. We are out at the intersection of Whit Davis and Lexington Road. We've got the Walmart shopping complex. We've got Athens-Clarke Park abutting here. We've got the residences to the side, and then we've got some of our pretty standard general business along there, gas station, dollar store, Tractor Supply there, some neighbors to the north and to the east. You can see here, this is the future land use, does not need to change. RM3 is compatible with general business, and then it goes into the park. Fairly unique property with having that sort of intense future land use abutted by one of our amenities, but nice as a buffer as well. So we've got the rezone request here. So CN, a lot of CN along the corridor on this side of Lexington Road on the southern side, general business across that corridor. You can see that this is a sort of solitary RM request in this area. We do only have, I believe, 3 RM parcels in town, so it's kind of tough to have compatible zoning for RM. We find the future land use and the commercial along this corridor to be sort of in line with this request, which is why we're recommending approval of it. And then having that buffer of the park space, it isn't that abrupt sort of change right into a single family neighborhood or even a multifamily neighborhood like we have in other areas, particularly directly across the street on Whit Davis Road. So here's a look into the property, former, I believe, nursery space and restaurant space, buffet space before that. It has been torn down since 2012. It was close to 2012 when it was torn down from all the records we had. And then you can see there is some of the concrete still on site and then some trees growing through that concrete. You can see just a little bit over here. So I believe this is the dollar store. That gas station will be right here. This does directly abut the park. This is more of the natural area of the park over towards the World of Wonder and with trails connecting through to the ball field side of the park as well, off of Lexington Road. So here's the non-binding plan that they're proposing. You can see the front portion and the rear of it are to be at 3 stories. The interior of it would be the 4-story units. Elevator access is what's being shown here, parking along the side, detention to the rear, and then you can see Whit Davis right across the street from Firewood. So we find this to be compatible with the 2023 comprehensive plan. It does call for affordable housing variety. So this is a little bit unique as a type. We are looking at a non-binding plan here, but from what is proposed, it would be a unique opportunity for affordable. They're targeting seniors specifically in their request, but again, in a non-binding way. It is close to that commercial node. The Walmart shopping center across the road on our current future land use efforts is looking to be a neighborhood center. It was shown as a commercial node on our growth concept map that was accepted by the Mayor and Commission. Also adjacent to the county park, providing amenity opportunities. There's also transportation options out here, obviously car travel, but we also have some transit lines and walking paths and sidewalks through this area and along a lot of the east side and definitely Whit Davis Road. Consistent
consistent with the surrounding future land use map with the corridor, commercial sort of uses there abutting it, and the park use on the southern and eastern sides of it. And also consistent with the ordinance with, not asking for any waivers or requests there, so would be subject to following the ordinance. Non-binding plan for that age-targeted affordable housing, seeking tax incentives. There are some sanitary sewer issues to address, but Public Utilities has stated that there is a solution available here. So they are recommending approval. And you can see there at the bottom that staff is also recommending approval. And that'll conclude the staff report.
Thank you, Mark. Thank you, your applicant.
Thank you, David Ellison, 2500 Gainesbridge Road, Athens-Clarke. Here on behalf of the applicant, we're here to seek a straight rezone to an RM3. As you can see from our application, we are seeking to build a low-income housing project using the low-income housing tax credits. We are not seeking to participate in the inclusionary zoning ordinance because we do not need any of the density bonuses. But even though we will not be participating in the inclusionary zoning ordinance, we would be subject to a land use restrictive covenant by participating in the low income housing credit program. So even though there is no zoning restriction as to our intent, there will be a restricted covenant that binds us to the government that we will be participating in this program. The plan right now is for 35 units at 60% AMI, 11 at 50% AMI, and 6 market rate. The goal is to have this be age restricted, but we need flexibility and do not want to make that a condition for the zoning of this property. Our plan is try to get approval in May from the Mayor and Commission. So we meet our deadline with the state of May 16th of next month. Beyond all that, though, we believe this meets all the requirements for a rezone. It's compatible with the future land use map and the comprehensive plan. We do not need to amend the future land use map at all, since RM3 is compatible with the underlying future land use map. What's notable is that we are offering affordable housing within walking distance of a commercial node. These are 2 of the key components of the comprehensive plan. We're also going to be increasing access to green space because we are right next to the park. What's a great feature about this property is we're going to be offering a transition of zoning from the commercial corridor to the single family house across the street. So we think that's a real feature, a nice feature here. And in staff's report compared some of the design regulations we see in zoning as it currently is versus RM3 zoning. And it's really not going to be increasing the scale or otherwise being incompatible with the surrounding neighborhood. All things considered, we think this is a great project. We understand there's a sewer capacity issue, but we're on that. We feel confident that we can address those issues. And at the end of the day, we don't think that we're going to be having an adverse impact on adjoining properties. They're already developed, and there's a reason why this property has been vacant since 2012. We think this is a great project for the community that also satisfies many objectives of the comprehensive plan. My clients here, if you have any questions in particular, and if you have any questions for me, I'm happy to answer them. Thank you.
Thank you, Mr. Ellison. Is there any member of the public here who wishes to speak in support of this application? Or in opposition to? All right, that concludes the public comment, and we will bring it back behind the rail. So, Mike and then Kristen.
I don't have a whole lot to say about it other than that, I tend to agree with staff on this one. I think I'm for approval.
I was going to make a motion for approval.
Yeah. Motion approved by Kristen, second by Jennifer, and the discussion of the motion. I'll just say real quick that it seems like a slam dunk, easy yes. I appreciate everything Mr. Ellison said, and affordable housing, Yes, absolutely. Affordable housing within walking distance of a commercial node. Double yes, and then right next to the park too. That's just fantastic. It's a great project for that particular site. And so I think it sounds fantastic in every way. Any other comment before we vote?
Of course it.
All right, Stephen.
Motion to approve, Morales,
Yes.
Weiss.
Yes.
Beresford,
Yes.
Laughlin,
Yes.
Pass,
Yes.
Sam,
Yes.
Anders,
Yes.
Lord.
Yes.
Motion passes unanimously.
Picking up momentum. Quick, go quick. Two more items and then a couple of text amendments. So next item is 220 College Avenue.
Right. Hello, Planning Commission. My name is Molly DePriest. I'm on the planning staff here. I'm presenting to you 220 College Avenue, use 2025-03-0435. Request is for special use in our commercial downtown district. They are requesting approval for a bar downtown with an occupancy of more than 100 persons. Only proposed change to the exterior of the building is an exit door for fire safety. Because this building is in our historic district, it has gone before the Historic Preservation Commission already, gotten approval for that exterior, the exterior door for it. And all proposed interior changes have been reviewed under the plans review process already as well. They are, the only approval they need left is from the planning department, and that would come with this approval of a special use permit. Other departments have already seen it and approved. I'm just waiting on this one last thing. Right, this is an aerial view from 2021, which accurately represents the current conditions of the area. Here we are facing College Avenue, and down here is Clayton Street. This is the College Avenue Square, College Square. And the building you can see is surrounded by similar commercial uses as shopping, retail, and offices. This building here, the square, is the Washington Street. As you can see, there's street parking along the way, but these commercial uses do bring a lot of foot traffic as well, especially with the nearby apartment buildings and sort of thing. Right, future land use for this property is downtown, which encourages retail and entertainment uses that are less auto-centric. And so definitely be included in this use. And this change would just be from commercial downtown to special use. In commercial downtown, they don't need to the zoning. And this is the proposed floor plan for the bar. The bar will be on the main floor of the building. As noted in your staff report, there are apartments above and some offices as well as another bar that's over here on the left side, a smaller bar than this proposal. And there would be a mezzanine level added as well in this main floor. This is our College Avenue elevation, showing here where the suite is that is proposed for the use. Entrance would be red squares here. And then this is the East Clayton Street side. This is where the exit door that the HPC has approved would go. There is a ramp that comes up from here and goes up to this now closed area. It used to be, this area used to be a Wells Fargo, and there was an ATM that was there, but now it's been boarded up, and it would just stay that boarded up wall. There is a recommendation from Transportation and Public Works to get rid of that ramp, but it is just a recommendation, not a requirement. That's noted in your staff report as well. So this, we see staff sees that this is compatible with the 2023 comprehensive plan, would encourage more business downtown. It's compatible with the future land use map, zoning map, and ordinances. So we see them, and that the special use criteria have been satisfied. So staff recommends approval. Includes the staff report.
Thank you, Molly. At this time, we will hear from the applicant.
Good evening. I'm Brett Thurman, Armitage Matheny Thurman, and I represent the owner of the property, Dr. Fred Warman. And our firm also represents the proposed business owner and operator that wants to lease this space for a bar. I don't want to go through everything that has been said here tonight because quite frankly, I agree with staff since they've recommended approval. And don't want to carry on too much over that. I just want to make one thing known, and this wasn't in my report, but the space has been marketed for almost 2 years. It's been empty ever since Wells Fargo left. And a clothing store looked at it, Bojangles looked at it, a barbecue restaurant looked at it, and a Michi's restaurant also looked at it. And couldn't come to agreements, or they couldn't get the space that they wanted, or whatever the reason why. And those inquiries for that use just couldn't be done. And so Mr. Kim comes along and he wants to put an Athena bar here at this location. And so they've reached an agreement and we've done a design for that. And that's going forward. The plans have been reviewed. And the HPC has reviewed and approved the fire door there that's shown on the Clayton Street side. I missed the thing about taking out the ramp that goes up to the thing, goes up to where the ATM used to be. I'm not sure whether there's some basement there underneath the sidewalk. And so there's the complications there related to that. And so I'm not so sure that can actually be taken out. So I'll bother you further and wish that you would hopefully recommend approval to the mayor and commission. Thank you.
Thank you, Mr. Thurman. Is there any member of the public here wishing to speak in support of this application? Or anyone here wishing to speak in opposition? Bring it back behind the rail. Who wants to?
Say, I used to bank there at Wells Fargo, so I'm familiar with the space, and bar seems like a good use for it. It's very nice and big and open, and I could see how it would be problematic for other businesses being so large. So bar sounds good.
I have to second to say, it doesn't seem that the ramp issue is that big of a deal. It's kind of nice to have another, I don't know if there would be an ADA entrance into that bar otherwise, but I don't see the ramp being that much of an issue. I have no problem with the bar.
I assume there would have to be an ADA accessible entrance to the bar.
It's not through the ramp.
Okay.
Right.
Yeah, the ramp doesn't actually go anywhere, right? It just
It
used
just
to
goes up
go
the
up to an
ADA.
ADA.
It looked like it was going to those front doors.
Yeah.
Or-
No, it doesn't go to anything, I don't think. It was just like an ATM, because there's a door at the front,
Okay,
and then they're adding a door at the side.
so it would be by that door at the side, but it's not irrelevant to that
Yeah,
door.
because it goes in the wrong, it goes in the other direction.
Okay.
Yeah.
The ADA
Using those ATMs.
is discussed in plans review.
I would think so, yeah. So we don't need to worry about ADA accessibility. That will be discussed in plans review. DPW recommends removal of that ramp just for sidewalk capacity.
It's an encroachment.
Is that, okay, it's an encroachment.
But structurally, and the applicant said it is interesting the basement for that building does extend into the right of way, below grade, right above the ramp. So it is a complicated thing to remove it. It may do more harm than good. So that's why it was sort of a soft suggestion from Transportation and Public Works. And is that fair, Kyle?
Yes.
Yeah. Yeah.
Okay. Does planning commission get a discount on drinks if we vote rude?
I think there's something in our bylaws. I got it already.
Question.
That's a great question.
I'll make a motion to approve.
Motion approved by Kristen, second by Sarah. Any further discussion? Stephen, take it away.
Motion to approve. Alice,
Yes.
Please,
Yes.
Beresford,
Yes.
Laughlin,
Yes.
Pass, Sam's,
Yes.
Sanders.
Yeah.
Lord. Yes. Pass unanimously.
Yeah. And then Barnett-Scholes. It's gonna get late enough and where they're gonna use the library site. Yeah, and what, our report.
Joanne DeJasperin, planning staff. I'm presenting, oops, went too far. The rezone request for 1030 Barnett Shores Road. They're requesting a rezone from RM2 mixed density residential to government. No future land use change is needed. And this is for the construction of the East Side ACC Library. Pardon me. It's a 6.29 acre wooded lot. It's currently undeveloped and sits on the western side of Barnett Shoals Road. Oops, sorry. This is Barnett Shoals Road. It's just south of Carriage Lane up here and Cotton Creek Drive across the way. The North Oconee Greenway runs along the western edge of the property. This is a mixed density residential future land use. This allows for limited non-residential uses at a neighborhood scale, such as a library. The request is compatible with the ACC zoning map. The government zone is appropriate for the area since it is a community use surrounded by residential uses. This is a view of the lot from across Barnett Shoals, kind of showing that slope up to the property, and then it slopes down towards the river at the back southeast corner. This is the non-binding site plan. It shows the main building. Oops, sorry. Right here with an area for perhaps some future addition. 79 parking spots, an area for outdoor programming, and then some links that would get you to the Greenway. Elevations show the front of the building. This is the front that would face actually the parking lot. This is the elevation that would face Barnett Shoals. This would face the Greenway, and then this is the view of the backside for loading and unloading. Another conceptual view again. Oops, sorry, I keep doing the wrong button. The front of the library and then the Greenway side of the library. So staff finds that this is compatible with the comprehensive plan, particularly as it encourages parks and schools to be located as focal points in neighborhoods. Its linkages to the Greenway allow for walking and biking as well. It's compatible with the future land use, doesn't require any changes, as well as the zoning map. So therefore, staff recommends approval. This concludes the staff report.
Thank you, Joanne. Is there any member of the public here wishing to support of this now?
Is there like with the applicant? Yes.
Oh.
Is that applicant?
You can do that. Yeah, you can speak.
I don't need to. I'll be super brief. This has obviously been through I'm John Simon. I'm one of the SPLOST project administrators.
This has been through a site selection process with Athens-Clarke County. The site has been approved by the mayor and commission. The schematic design has been approved by the mayor and commission. And so we're switching to a government government zoning to be consistent with other government properties across the county.
Thank you, Austin. All right. Is there any other member of the public here wishing to speak in support or in opposition to this application? All right, I will bring it back. Rail, and who wants to lead off?
I just am very excited about this because I'm on the SPOS 2020 committee and I was not on the site selection committee for this, but I've watched how hard it's been to get this sorted out. So this is great. And what a cool location. So, okay.
Yeah, it's nice. It's right there on the Greenway. That's super cool.
Yeah, it's awesome. It's on the Greenway. It's also kind of right across the street from that Deacle Lake development that we recently recommended approval of. And it's going to be like
Right down the Greenway path.
people living there, so super accessible to them. So it seems great.
Looks
good. I'll make a motion to approve.
Second.
Motion by Mike to approve, second by Carrie. I guess we can just do like voice vote on that one, right? Or do we need a roll call? All in favor?
Aye.
Aye. Any opposed? Motion passes unanimously. And we're almost done. We just got two little bitty text amendments.
All right. First text amendment that I want to talk about is related to chapter 9-4 approvals. Quick summary of this is on the cover memo that was sent to you, but what this is proposing to do is to put the administrative hearing officer in place as the appellate entity rather than planning commission. Items that would presently come to this group. And we talked a little bit earlier about why that is arguably a path. Happy to answer any questions you may have about what's proposed.
So this is hearing board decisions for which type 4 decisions, so the ordinary appeal process is, it comes to us, and that's the one thing that we make the final decision rather than just a recommendation.
Right.
And so we see a couple of those every year. So this would amend the code to take those out of our.
Please, we can do the dance shortly.
Okay. Take it away from us and give it to the administrative hearing officer. That's right.
Who is the administrative hearings officer? Like, I mean, what, do they live in the planning department or like?
It's the municipal judge
Oh, so it goes to a judge.
or the judge's designee, I guess is the business.
Okay.
That seems good.
Yeah.
The judge handled it.
And so that's one reason I think that this has been proposed is you have a judicial officer who is familiar with the standards of appeal and knows how to apply, for instance, any evidence standard, things like that. So, you know, they're comfortable in that world. And so I think that's one reason for this proposed text amendment.
Does this change? I remember when I was on the hearings board, we had an appeal once of like a staff decision. Is that gonna go, is that part of this at all, the appeal?
So there was a text amendment about that previous to this one, that staff determinations go to the administrative hearings officer.
Okay, well, that was good, because that's better than the hearings board, honestly. We didn't really, it was very far outside of what we normally did. So that makes sense. Good.
Cool. Do we still get our $10 a month, or is it more than $8?
There's been no discounting.
So you're solid.
One less thing you have to do, less dollar.
Yeah, I think this makes sense because it seems like, especially the last several years, I think Austin, John, you guys just paid a lot more attention to making sure we understood the limitations of what we could do as a body. And so it was every time we had one of these coming, there'd be this big like effort put toward making sure, especially newer planning commissioners knew how much we can't do actually. And So this just makes it a little bit, I mean, I like the whole spirit of what it's doing. That's always seemed like it puts us in a weird position because it's so tense. We want to like retry it.
Yeah.
So I think that's a good idea.
This is like a recommendation or like what, are we approving this? Like what is the?
You would, just like any other item on your agenda, there'll be a motion and send it on up to the mayor and commission.
I'll make a motion to approve.
I'll second.
Motion by Kristen, second by Jennifer. Approve. Any further discussion? Stephen, do you want to call the roll on it?
Motion to approve Morales,
Yes.
Reese,
Yes.
Beresford,
Yes.
McLaughlin,
Yes.
Tass,
Yes.
Sam's,
Yes.
Sanders,
Yes.
and Malone.
Yes.
Motion passes unanimously.
All right, what's my last text amendment? Similar vein. So in chapter 7-4, which lives kind of outside of zoning, Title 9, this is Title 7. Sign code does say the planning commission shall be the body to variances regarding sign requirements. So this would, again, take the administrative hearings officer and situate them as the appellate body for hearing things related to sign issues. And there were some deadlines that we needed to clean up. So there's some timeline dates that periods of review and that type of thing that need to be bumped out. So that's part of this.
Just the yellow highlighted bits additions. This is not to go red line format.
So the yellow is what's changed. The strike through in most cases will precede it. So on pages 2 and 3, you'll see where the numbers.
Yeah.
They changed. And then, yes, at the very top. But
Right now it says, and like line 1 would say, property owner or sign contractor may apply to the hearings board. So the yellow bit has been added in. Okay.
So this would be appeals of the variance decisions that the hearings board makes on the signs?
that's right.
We had a lot of those too.
Okay. Any discussion of that?
Motion to approve.
Motion approved by Kristen.
Yeah.
Second. Second by Mike. All in favor?
Aye.
Any opposed? Okay, motion passes unanimously. That brings us to the other business section. All right. One is commissioner's report. I have none. Other than that, I want to go home.
Earlier than I thought it was gonna be, honestly.
Is there a future land use steering committee chair's report?
I'll make it brief by saying, it hits the road tomorrow for public input and opinion. That meeting will be at,
Authentic?
yeah. And then immediately the next day, and I won't go through them all, but, at 5 Points, I believe it's Fire Hall, and so on and so on. If you would like a list of all of this, I don't know if y'all send it out to us or not, but we can, either staff can or I will. But please, have a look, and then it'll come back to the future land use steering committee with some feedback. We'll either adjust or not, but we'll take the thoughts of the public, correct, and then we'll head to this table and or to this group, and then move on to the mayor and commission. So good progress.
Thank you. Bruce.
Okay, next month we do have a meeting. You would feel like after tonight, we shouldn't.
This didn't clear us through.
Well, we tabled too much
The
stuff.
fiscal year at least.
Right, but that's so wrong. So there's 4 items that, plus you're including what happened tonight, or there's 5 we've received? 5
Before tonight.
5 before tonight. And then on the subject of some of the things that were tabled, deadline's already passed. So it's not that we think procedurally we can bring things back in May. It's a question of, will things be ready? So certainly we have an applicant we need to coordinate with. We have a text amendment that we need to work with our legal team. We can pull the numbers very quickly, but if there's the discussion about the neighborhood sort of relief aspect of what y'all asked for, that may take a little more time. So we'll put our heads together and think through that to see if we can make it in May, and if we can.
And you mentioned doing like a special little session to talk about it. I would do that if it was needed.
So just a quick reminder on that, we are very sincere in our intention to take the 2 cycles that don't feed to the mayor and commission because they're off. We want to take those planning commission dates and use those as work session opportunities, education opportunities, and text amendment opportunities, so that we can maybe bring as many of those text amendments to that kind of format and not have it be a part of a normal business voting session. That is still what we want to do. That would be June, December. And again, that's, if we've got business that rolls over by virtue of tables, we're going to have to deal with it. But that's still what we want to do. And that's a new thing for us, but I think we have lots of stuff to talk about. And certainly on the heels of future land use and the text amendments that are going to evolve out of that, we're going to need to be working together. That's it.
Item 4 is miscellaneous announcements. Does anybody have one?
I would like to thank Kristen for bringing in snacks.
Yeah.
Thank you.
I'll second that.
So before you leave, I want to take a photo.
That was awesome. We should make this a tradition. We were talking about that. We should, everyone brings a snack, rotate snacks. I don't know, just something to propose as
I think Jen might call it the recusal lounge.
I know, we had so many. Wow. Or is it the penalty box for like in hockey? You gotta go. All right. Too many conflicts. You gotta go to the room.
All right, the chair would entertain a motion to adjourn.
I move to adjourn.
Second.
All in favor?
Aye. We did it. Opposed.
Good job, everyone. That was.
Yeah, that was faster than I thought it was made.
It really was.
Especially after that first one took like an hour and a half.